I will have one more. That's not. All memos don't. You will decide it much. Please.
Fourth mute ஆயிருக்குமா?
Please give the memos, no problem. We'll try and fix it. Maybe tomorrow, maybe day after. Around tomorrow. What do you want, sir? Vacating stay. Have you informed the other side? Please inform them. Give the paper. Inform the other side. Have you heard that matter a bit? Please give the memo.
There were 22 SSL students. Admission ticket. There is a change of school. Already notice
School, ಹುಡುಗರಿದ್ದಾರೆ. 18. Mahesh Uppin.
My lord, may I make one submission?
Withdrawn, dismissed all interlocutory application disposed.
The body is not that. The single order. From the last 7 years to today, they are not done.
And it wait for a while. 7 years, another 7 days. There's no problem in giving you, but the point is the pressure is high. I told you.
My lord, may I make one submission? My lord?
Yes.
My lord, list number 3.
Yes, please. Yes, please.
List number 3. Item number 1.
Yes.
The accused is present before your lordship.
Right.
My lord, the learned single judge, the matter is before the learned single judge today. The court has asked the same executive to come to court for settling the matter out of court. So I talked to Mr. Aegis, he was also. The matter is coming up for a discussion today for amicable settlement.
Very good.
A week's time, my lord.
If you want, we'll give a little more only, no problem.
Please, my lord, have obliged.
All right.
Directions. These 3 directions matter. Adjournment beda anta.
Interim.
Direction matter.
My lord, he is my matter adjourned, my lord.
1 minute, sir. Srinivasan and Mr. Kasturi is making a submission that today you are discussing the matter.
He only mentioned.
Interim order. Asking that the admitted amount of 2,000.
Oh, yes. Oh, you are not given the admitted amount. Sorry, that we can't adjourn, Mr. Kasturi.
I'm very sorry. Your lordships are being misled. I'm unable to come physically to the court. Kindly give me 1 week's time. I'll come and appear with your lordship. Please. I am not able to come today because I put some bandage to my leg. I can't come.
Sir, please tell us. The senior most perhaps in age, when he's. What do you want us to do now?
What will be, I shorted 886. In the meantime, we will also try and talk. If they are ready to resolve it, we are not the person.
Yes, that is what Mr. Kasturi is. See, that's what he's saying, that today there is some discussion.
Let time be granted because the senior counsel I have due respect.
Right.
But only thing is, let it not be for a week because otherwise we have waited for almost a decade now. Now, I'm just telling, let us get at least the interim release. If not,
How this court is being misled, I'll come and explain it to the court.
2-3 days may be granted for us to talk, it is resolved fine. Otherwise, may not something. All these people are now, there is a infringement order. There is lots of actions and blood.
See, this court is sitting for 2-3 days only. Thereafter, last 2 days, the sittings are outside Bangalore. Therefore, please come on 19th. We'll see what can be done. Yes, same day next week. Thank you.
That's all right.
Real number 69.
69.
69. This matter, Larnelli AAG, Kiran Ron is appearing, but there's some inconvenience for today. The last may kindly have it tomorrow.
Tomorrow, Bekante.
They also VSS, 3 people are coming there. They are only taking time.
Tell us what he wants tomorrow. ಅದೇನ tomorrow ದಿವಸ ಆಗ್ಲೂ ಹಾಕಿದ್ರು ಅದೇನ್ ಸಾಲ್ವ್ ಆಗಲ್ಲ.
Chance of frame ಮಾಡಿದ್ರೆ ಆಗುತ್ತೆ.
ಅದ್ ಏನ್ ಮಾಡಿದ್ರು ಆಗಲ್ಲ.
That they are going to want to come.
24 serial number 29.
Batch case.
What is this? What is this matter about?
ಇದರಲ್ಲಿ ನಮ್ದು ಡಿಸೇಬಲ್ಮೆಂಟ್ ಇದೆ ಮೇಡಮ್. ಇದು ಅನ್ನೆಸೆಸರಿ ಕ್ಲಬ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. 34
Huh? 29. Balance matter, you have no problem. And you have no objection for listing later. Please understand. 29, you want it today. Balance matter, you have no problem. Correct? Not connected. So, balance matter-
ಡಿಟ್ಯಾಚ್ ಮಾಡ್ಬಿಟ್ಟು ಬ್ಯಾಲೆನ್ಸ್ ಡೇಟ್ ಕೊಡೋಣ.
You want, when do you want? You take it in March then? All. All. Don't say March. Anyway,
ಹೌದು, ಇದಿಷ್ಟು
disabled. 29, not before my Lord Justice Shivashankar Court. 29.1 to 40, 50, 50, all. 1 minute, 55, 29.1 to 29.55, post in March 7th or March 12th, whatever. All right? Interim orders extended. Which matter? We are not dealing individually. They will all come in March. You know. Do what? Those miscellaneous don't keep mentioning. Do what you like. Matter is not on board now. It's gone. All right. Thank you. Serial number? Serial number? 46. What do you want? Mr. So-and-so submits that appellant has passed away. Chandrasekhar Reddy, where is the? Here, Chandrasekhar. The advocate for appellant submits that appellant has passed away. What about the other cases? Then we must know, no, then we must mention when it comes. We don't know whether they have urgency, they don't have urgency. We can't just take away one. 30? 1 minute.
ಆಮೇಲೆ ಫಾರ್ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತೀವಿ.
Other. 59. Yes, what do you want? Sir, we take it in March. Why do you want every day listing this? We have 3 days, 4 days sitting. ಕೊಟ್ಬಿಡಿ ಇವಾಗ ಮೊದಲು ಚೆಕ್ ಕೊಟ್ರೆ ಮಂಡೇ ಹಾಕ್ತೀವಿ ಇಲ್ಲಾಂದ್ರೆ ಇಲ್ಲ. If you how much DDM must be?
From to 5 lakhs.
No. How much is the total settlement?
They have offered for 12 lakh. We have offered for 17.
ಅಂದ್ರೆ ಅದು ಆಗದೆ ಇರೋ ಕೆಲಸ.
And we have paid for.
ಸೊ ಇನ್ನು ಆಫರ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ, ಅದು ಆಗದೆ ಇರೋ ಕೆಲಸ.
Monday, I will definitely will come to the.
If you don't do it on, because the pressure is so high, if you don't settle on Monday, we'll impose 1 lakh rupee cost. Take a date, no problem. If you report, if both of you report settlement on Monday, if you don't report settlement, we'll impose cost, because at the cost of other cases, you'll be coming here. Please don't spend time, sir. We have no time like this. You have an option. You want on Monday very specifically, we'll give you Monday. But be ready for a cost if you don't comply with it. ಇಲ್ಲಾಂದ್ರೆ ಕೇಳ್ಕೊಂಬಂದು ಆಮೇಲೆ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹೇಳಿ. ದಯವಿಟ್ಟು ತಮ್ಮ ಕ್ಲೈಂಟ್ಗೆ ಎದುರುಗಡೆ ಕ್ಲೈಂಟ್ಗೆ ಮಾತಾಡ್ಬಿಟ್ಟು ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹೇಳಿ ಯಾವ ಡೇಟ್ ಬೇಕು ಕೊಡ್ತೀವಿ. ಆಲ್ರೈಟ್, ನಾವು ಕನ್ನಡಲ್ಲಿ ಹೇಳಿದ್ವಿ. ಯು ವಾಂಟ್ ಅಸ್ ಟು ಟೆಲ್ ಇನ್ ಇಂಗ್ಲಿಷ್ ಆರ್ ಹಿಂದಿ, 3 languages we can tell. So we have told you very clearly, mister, if you are settling it on Monday, we will give you on Monday. If you don't settle on that day, we'll be imposing exemplary cost because pressure is high on. So far as time is concerned, is that clear to you? Yes. Learned advocate submits despite, learned advocate insists that matter be listed on Monday to report settlement. Full stop. Adjourn, making it clear that if settlement is not reported, appropriate orders will be passed. Yes. Serial number 1. You want, yes, withdrawn, dismissed all interlocutory application. You are Mr. Sanjay Krishna. Okay, appearance. Yes. 40. 1 minute, sir. Just hold on. RP. It will come in March. March, yes. Yes.
Yes, we reinstated the letter. When we reinstated, he is paid salary and office subjects would not submit over. We have already acted.
So what do you want now?
Because another form is no more. It would be listed for final.
Ms. So-and-so submits that Mr. Anantharaman, advocate for respondent, has passed away, as prayed for, call in March. That's all.
See, for 14 we filed a memo for withdrawal of the writ petition as well as the writ of appeal.
Both you are doing. Any objection from the other side? For that. Learned, so-and-so Jayant Dev Kumar submits that praise seeks leave to withdraw the writ petition. No, first writ petition hodre, consequently seeks leave to withdraw the writ petition. Full stop. What is the matter about it? You challenged it.
I challenge notification.
Now you don't want that.
Now I have been made the.
What is the finding?
Finding was that I am not a professor. Now thereafter, subsequent events, I have been declared a professor by the institute itself, and I am in charge director. So therefore, I don't intend to proceed.
No objection, madam. Any other contesting parties are here? Rajiv Gandhi, Sanjay Gandhi, Sanjay Gandhi. You are appearing for Sanjay. You are the institution. She is the government. All right. Sri Bipin Hegde for Sanjay Gandhi Institute and GA. Learned GA have no objection. Leave grant. Yes, we'll permit you. Leave granted. Petitioner permitted. Appellant permitted to withdraw the writ petition. Writ petition stands dismissed as withdrawn. Consequently, appeal is rendered infructuous. Appeal also stands dismissed. Accordingly, it stands dismissed. As prayed for, Mr. Bipin Hegde is permitted to file memo wakalatnama in 8 weeks. All right. Submissions placed on record. Which one? Serial number. You want posting? You want to withdraw? What do you want? What is the urgency?
All other your courts of questions have already been written in the provision. Only my question is there. For want of the order earlier. I want.
So end of the financial year is better, March. Not possible.
Please.
Sir, there is no time to take matters.
All others were questions.
My second list. What do you want? 29 will come before some other bench. 29.12. My lord is disabled. 29 will come before some other bench. Tomorrow, all. Only 29 tomorrow. Rest all other dates. For what? For what?
Selection of the formation of the target range management unit, which has been provided to the hotel villages. Some of the villages have referred to clearly. We will let know tomorrow.
Not possible. Please move it later. Not possible, sir. Please, when the Honorable, the new Chief Justice comes. Yes, next.
The last, right,
Yes,
Serial number 31, please. Here the interim order passed by Honorable Court.
31.
The SLP is filed before the Supreme Court. It is likely to come up this week. Your Lordship may kindly have it next week.
I have some objections. Make my submissions, let the matter be called. They have accepted those orders. I'll show your lordship.
Challenge it before Supreme Court.
After accepting it, I'll show you. I have some difficulty.
Kindly listen to.
Sent the vote 6 months ago.
Kindly listen. If the matter is before a court superior to this
Lord,
court.
it cannot, with greatest respect, your lordship may hear me for 10 minutes. It cannot be done. I have concluded, I have contract for saying to me.
Then come when the matter is reached.
Here. Matter pertains to the Tribunal position.
All right. Advocate submits that the matter pertains to Shivram Karan post before the special bench. 2 weeks, March, fourth matter. Same order. We grant you 2 weeks whenever you want to do it. No problem. 2 weeks. Same order. Yes. What do you say? 1 minute. What do you say? Where will you deposit? Entire money. 25%. Court has directed you to deposit 25%. That also you are not done. What is it's money suit, is it? Yeah, no objection. You want 60 days time. How much money he has to deposit, Mr. Both of you are not saying. You must say the figures. We don't have file. We don't have the calculator with us. How much money? You must pay 1 crore. So how much the court has directed you to pay? Mr. Jaisima, don't you understand what we are asking the question? How much the court has directed you to deposit? 1 crore. Yeah. So total debt is 5 crores. This is the problem with by and large every lawyer. The question, it must be that such a clarity must be there. Total debt is 5 crores. Court has directed me to pay 1 crore. So that you see, there will be, then what? So have you paid this 1 crore? When was the order passed?
12/22.
What is the suit for? Recovery of money. Maybe he has suffered an order. No, he may be very generous. Court should not be, because we must be very clear on, because we have set principles. The question is if the defaulters will not get an order in this court.
Yes.
We made this point very clear. You argued on, I think, online the other day.
We know, we told them.
He doesn't want to take money, we have no problem. But you have to comply with that order. That's the whole difficulty of 1 year and taking this is why we, in this court, we don't grant interim order, all right, 8 weeks, 10 weeks. First, bona fides, then the interim order will come into effect on or we'll vacate the interim order. There's no two ways about it. Or you increase the interim order quantum, then we'll consider. Sorry? Oh. Got it. No, sorry. That's a different matter. Like 5 crores. 25%. This is dated total like
25% of ಕೆಲವು ಕಟ್ಟಬೇಕು. ಸ್ವಲ್ಪ ಕಟ್ಟಿ 25% ಅಂತ ಕಟ್ಟಲಿಲ್ಲ ಅಂದ್ರೆ now he has to pay 50%, not 25%.
Jasima, there is another peremptory order you have. If the compliance is not done by 5/12/22, you have to deposit 50%. What do you want to? Now you have to not 25%, you have to deposit 50%. No, we are not on merits, because we are not on merit. Now it's only on. No, but a bench has passed an order. If you are aggrieved, you have to challenge it in the manner known to law. What have you done? No, you can't be before this court because a coordinate bench has passed the order. Then we'll post it before the same bench. Then we'll post before the same bench. Learned advocate for this court on 23/1/2024 has directed for payment of rupees for payment of 50% in the event Hague body. This court had initially granted interim order subject to payment of 25%. Full stop. On 23/1/2024, it is recorded that in the event the appellant failed to comply
In 2 days.
within 2 days therefrom, the 2 days from 5/12.
Our order, 2 days of this order. Period of 2 days before this court.
If appellant defaulted in the making payment of 25% within 2 days therefrom, the appellant was directed to pay 50%. That order is not under challenge as on date. Full stop. Learned advocate for the appellant submits that appellant may be granted 60 days time to deposit a total of 25%. That's what total of 25% into bracket approximately rupees 1 crore, full 1 crore, rupees 1 crore. But this code refers to percentage. Rupees 1 crore, full stop. Learned advocate for the respondent opposes the same in view of the modification, in view of the previous order, in view of the order dated 23/1/2024, we deem it appropriate to place the matter before the same bench, ordered accordingly next week, or next week. What is the matter about?
This is acquisition, right?
The same notification in question that we, upon by the division of this court and after in the second division, I had permitted so that in the second set by mistake by the second and not permission.
So today, yes, madam.
In 8.1, it is a state appeal. This is with regard to acquisition proceedings under the PDA. Now,
Under the? Under the?
PDA. My lord, they have filed a memo for disposal of the case. I haven't received the memo. Firstly,
Who have filed?
the appellants in the first matter.
Appellant in the first matter. You are the appellant in the first. You are BDA. What has happened? What have you challenged?
Sorry, not the appellant.
The portion of the land is, as a CS act, it was allotted to the police station. And police stations are constructed. By that, now they are kind of memo dating that being a within that, and they were fed. Therefore,
What has the honorable single judge done?
well, they will not, allow the expression and.
Holding
Holding that the scheme has been lapsed and.
scheme has lapsed. That is why you have come in the appeal.
Regard to the petitioner's portion of land under 27.
The matter requires hearing.
My lord, but the only thing is, there is firstly a delay of 31 years which has.
It's all right, but matter has to be heard, not 22 matter.
Memo for disposal, that is.
Same issue. The notification in question that is relating to the same notification. Entire issue has been concluded in the apex note in so that may kind of easy.
So,
That is.
no, fair enough, sir. There is, the same is not admitted by the both sides. So,
So that may kindly, that's a very start. In fact, the same notification in question that has been affirmed by the Supreme Court, and that's why I am not paying.
so the matter has to, we have to hear you, we have to hear them also. Give them an opportunity. They may, is it covered? If all three say that it is covered, it is covered.
And can I show me that?
Correct, sir. So now you have to show that it is covered and we must give him an opportunity. No, it will come in March.
No, wait, in fact,
They
the
have-
Yeah, please cooperate. We have no time to hear these matters.
fact, the issue has been already agitated, of the effect court, and the issue related to same notification that has been. Now, in fact, the other finger said has been given all reasonings, that's why there is a sharp point, only whether it is covered or
Correct.
by a special petition order. That is the only sharp point. Next week, it may be kind to be any date of 28th or 21st. Of your lordship kind of.
All right, 21.
Available.
The state appeal, there is a delay of 54 days.
Let it, we will consider, come in the same stage. All right,
54 days.
54 days. Any objection? All right. Krishna has no objection. ತಾವಿದ್ದೀರಾ ಇದರಲ್ಲಿ? Connected ಅಲ್ಲಿ? I have no objection, respondents have no objection. IA 1 of 22 allowed delay control.
Let them give us a copy of the memo for disposal, my lord, I will.
Sadanand? But have you complied? No, have you complied with the order? All. What is this counter affidavit filed by such and such? All right. 1 minute, Mr. Kiran submits that counter has been filed. What is the matter about?
For injunction before the trial. Put the emergency notice. Thereafter, as a repetition. Repetition was learned in the speak about the matter of state before again is responsible. The going on, I have to head this construction.
And they reach to a stage where definitely this was either a declaration or property litigation, that's my problem. Hence, I'm before the Contempt that they not compared with the order. But yes.
So matter requires inquiry and hearing. Evidence has to be conducted. Can we pass an order on based on that's procedure is there?
Here before charge of postpone.
All right, here before charge 29th. You already have an order in your hand. According to you, they have violated the order. Alva.
The apprehension that this, what has happened is not, there are huge conglomerates. The property now may not in question for me, it's only about 1,500 square feet. They are also claiming another portion of the property which is of 40,000 square feet. So if they will just assert my property and then go ahead with construction, complain of an order so that it is not restricted as a.
So now that you have an order, interim order in your favor, and you have come to this court because they are violating according to you. So what further order is possible? And that one in contempt side, what order can we pass? Do that. That's a better option. Thank you.
The property does not belong to them. There is a clear demarcation of the property where you have a compound. The interim order is for the property which belongs to them.
Why are we discussing this?
I'm sorry.
Thank you. Next.
Appear on behalf of the appellants. Your Lordships, in this matter, on the last occasion, Your Lordship, we had submitted with respect to respondents 17 to 19 and 20 to 31. Your Lordships, if LRs of the appellants of the legal representatives who would be sailing with us, if we could request Your Lordship if it could be dispensed with, this would be
17 to 19, you want dispensation, correct?
and 20 to 30, 29 to 31, Your Lordship.
Correct? Learned the senior advocate seeks dispensation of notice on 17 to 19 and 29 to 31.
Your Lordship, this, we had also filed an application. Please.
Modilla. Eagle model.
Not dispense?
Yes.
Please file a memo then. Dispensation. No, it's not there, Mr. So you will make us to read the orders, understand the case, do all clerical compliances, and then tell you, sir, this is the problem. And you have a senior advocate for this.
Your Lordship, there was.
No, madam, sorry. You must either.
No, I understand.
If you don't know the order sheet, you should not make submissions.
Your Lordship, I shall have him do it today itself. The difficulty was there was also an IA for stay.
Please
and
permit us to do our job. Memo filed by advocate on record seeks dispensation of notice on 17 to 19, 29 to 31. Memo ordered notices on such and such dispensed. That's all, madam. Anything else?
Your Lordship, there was an application for stay. I shall not press on it immediately till the other side's also heard. The difficulty is this, Your Lordship, immediately after the order of the single judge, they have gone and changed the revenue entries, though we are in possession, and therefore at least a status quo till the next date of hearing, Your Lordship, and even a date could be fixed for next week.
Have you done that? Submission is that the moment the order was passed by the Honorable Single Judge, revenue entries were changed. Is it correct or not?
As per the court order, the revenue records has been fixed.
So maintain status quo regarding possession.
Please. No, if that is the case, then status quo will not affect him, Your Lordship.
From the day when revenue record stands in the name of the respondent number 3, as per the.
So status quo regarding possession.
Please.
Learned senior advocate Lakshmi Iyengar submits that immediately after, as soon as the order was passed by the Honorable Single Judge, the revenue entries have been changed in the name of the respondent, contesting respondent. Is to number 3. Submits that though appellant is in possession of the property, The revenue entries have been changed in the name of contesting respondent number 3 immediately after the Honorable Single Judge has passed the order. The advocate for R3 asserts that, admits the same and asserts that the possession is with him. Full stop. Srimati Lakshmi Iyengar sought for a status quo order. Respondent number 3 has no objection. Party shall maintain status quo with
Obliged.
regard to possession.
Obliged.
Connected matter. Steps in 2 weeks. Steps in 2 weeks. What is this? Production of pleadings, etc. Why?
Dispensation ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
Dispensation ಕೇಳ್ತಾ ಇದ್ದೀರಾ ತಾವು? Those papers are on record in the connected matter. Order on IA1 of 23 in 10.1, learned advocate submits that the papers sought to be dispensed, of which dispensation is sought, are already on record in connected WA number 58 of 2023, submission placed on record. IA1 ordered dispensation. IA1 allowed dispensation order. Next, another delay. 164 delay. Respondent
Issue notice.
notice on writ appeal and IA1 of 20. ಏನಮ್ಮ ನೋಟಿಸ್ ಆಗಿದೆಯಾ? ನೋಟಿಸ್ ಆಗಿದ್ರೆ ನೋಟಿಸ್ ಅವ್ರ ಸರ್ವಿಸ್ ಆಗ್ಬೇಕು. ನಥಿಂಗ್ ಇನ್ನೇನಿಲ್ಲ. IA1 ಹಂಗೆ ಜನಾರ್ದನ್.
An identical matter on last occasion. It pertains to the employees of private institutions. By sending the proposal for settlement of return.
Up till that portion, same.
The similar order will.
See, in an identical or whatever, what we have taken a view is, you know that. So, up from the date on which they, what is that? He was admitted to grant. They have made a statement that they will give hearing ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅದ್ ಬೇಕಾದ್ರೆ ತಗೊಳ್ಳಿ, ಇಲ್ಲಾಂದ್ರೆ ದಯವಿಟ್ಟು ಒಂದು ವಾರ ವೇಟ್ ಮಾಡಿ 29ಕ್ಕೆ ಮಾಡಿ. ಸೊ ಅವ್ರು ಅದೇನೋ ಹೇಳ್ತಾರೆ, ನೀವು ಅದೇನೋ ಹೇಳ್ತೀರಾ. even if we hear, we can't write that order. Sir, you have a choice. You want to accept pending all without prejudice to your rights, please accept. Otherwise, wait for a week and get it. Then 29th, nothing. Year model 29th. By consent, call on 29th. That's exactly we said. Undisputed amount they will give you immediately without any coding. ಅದನ್ನ ಅಡ್ಜುಡಿಕೇಟ್ ಮಾಡಕ್ಕೆ ಅಷ್ಟು ಟೈಮ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಶ್ರೀ ಮಹೇಂದ್ರ ಲರ್ನಡ್ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ submits that in similar cases, this court has permitted the government to comply with the order so far as the aided period, so far as the aided period, without prejudice to the appellant's rights in this appeal, no? All right. So far as complainant's rights in the writ appeal. ಅದೇ ತಾನೇ ಇಂಪ್ಯೂರ್ ಮಾಡಿರೋದು. ಫುಲ್ ಸ್ಟಾಪ್. 2476 ಅದು ನಿಮ್ದೇನಾ? ಆಲ್ ರೈಟ್. In writ appeal number 2476 of 2015, full stop. Sri Janardana has no objection for passing a similar order as in CCC 161 of 2023, making it clear that that any interim payment shall not prejudice his rights in the writ appeal. Yes, terminal benefits. Any interim payment regarding terminal benefits ordered accordingly.
1450 agreement.
Pensionary benefits not given. Why, sir? Mahendra? Nodilba?
You filed a wakalat, but the name is not reflected here.
Who has to settle? Why you are not settled, madam? Terminal benefits.
Our name is not reflected in here.
You are appearing for whom? You are appearing for whom? Who is accused number 2? Francis Delmangla. You are appearing.
You filed a wakalat, but the name is not reflected here.
You undertake to file wakalatnama. Yes, Miss So and so undertakes to file wakalatnama for A2 office to show her name. Counter in 2 weeks. Correct, but her name is not there. She has to file her wakalatnama 2 weeks. Yes. Siddharth Babura. Of course, we'll give a date. 7th, sorry, 6th March. Thank you.
Siddharth?
Yes, Siddharth. Appears. ಯಾರು ಇಲ್ವಲ್ಲ ಅವ್ರು ಕಂಪ್ಲೇಂಟ್ ಇಲ್ಲ.
16, my lord.
A16. A16, what I got to say, madam?
My lord, kindly pass over. My lord, senior is on his legs in another
pass over,
court. I'm
madam.
sorry, my lord.
It will.
I'm unable to hear. I'm sorry, my lord.
What is the matter, Mr. Pat? Malipat?
Regularization of the services has to be.
They are working now, no? Now, as of now, are they working? Then is all right. Then let it come in March. Yes.
My lord, kindly pass over, my lord.
Madam, not possible. Please cooperate. Thank you. Your clients are already working. You want regularization of service, correct?
No, my lord. No, my lord. We are all working. We had secured. They called for a notification, my lord, and 1 or 2 posts were reserved for us, my lord, and they had to absorb us, my lord.
So, as of today, you are working. Is that correct?
Please, 1 second.
Somebody wants to say.
May.
Sir.
Sir, the
Really,
matter,
sir.
we have been working for several decades now,
Correct, correct.
and the litigation itself is 10 years old.
Right.
Repeatedly, whenever we came before this honorable court, an undertaking has been given that will be regularized. And during the COVID lockout period, an assurance was held out that we are going to be regularized and therefore we should work. Accordingly, day and night we have worked during the COVID the period in the COVID war room. And nevertheless, till this day they have not honored. Therefore, we have again, this is the 3rd round or 4th round, we have come before this honorable court, and every time they have given an undertaking that they are going to regularize us. Until this day, they have not regularized. Kindly see the order that was passed in the last proceeding.
There was an affidavit filed on 25th July 2023, taking 6 months. Now, the director is present for the court. And now they are saying that's not this for misinformed, that is why.
What is the solution?
But they are preparing an appeal.
Sir, it is time that the warrant is issued for their appearance because they are so stubborn.
The deputy director is before the court.
No, he's not a party. He's not a
He's
party.
not a.
He's not a party. The parties are the secretary, principal secretary, and the director of the Bangalore Medical
He has given
College.
an undertaking to the
Yeah,
court.
they have not once, repeatedly they have given an undertaking that they will observe us.
It's Jyoti Prakash.
Sir, this is the 3rd round of litigation. May I request the court to kindly peruse the order?
Learned government advocate is making some submissions. So we'll let us hear.
Please.
Yes.
Then Jyoti Prakash, the deputy secretary, has filed an affidavit. Seeking 6 months time
To do what?
complain.
So why how many months have passed? All right. What is the ranking of that officer?
FP secretary.
IAS,
Okay.
not non-IAS. All right. So the deputy secretary to the government's affidavit, you are not, are you disowning that affidavit?
Now that the joint secretary is saying that he was misinformed. And we are trying to taking a review of the order.
Then get it done. Who's stopping you? After 6 months, you can't come in contempt court and say this. Then we'll post it for here before charge. Good. All right. Learned government advocate submits that the where is that affidavit?
Jyoti Prakash.
That an affidavit was filed by one Sri Jyoti Prakash,
Deputy Secretary.
working as deputy secretary to the government.
Department of Medical Education.
Huh? Sorry?
Para 7 of the affidavit, page number 3.
Yes.
Yes.
Who is the accused?
Accused in
The principal secretary and the director.
Well, Secretary.
Principal secretary of the government.
Please tell us, when there is an accused in CCC proceeding, who has to file the affidavit?
It is the accused, sir.
Then keep the accused present here. Sir, if you want to take court head on like this, we will not grant you 2 seconds time, not 2 weeks time. This is flagrant violation. Sorry, get your secretary tomorrow.
That they have done yeoman service during COVID period,
Yes.
risking their own lives.
No, is it the way that your officers may be asking you to do, or they may be asking you to, they may be giving you instructions in the manner that they like, but you are all government advocates. Why do you want to support their cause? Who has drafted this? Assistant Officer, the Advocate General. How can these things happen, Mr.?
Not proper. Consider. Accused has to file.
Submits that an affidavit dated 24/7/2023 was filed by one Mr. Jyoti Prakash, Deputy Secretary. In para 7, the para 7 of that affidavit reads as follows. Page 3. Full stop. Andre opening he performed. Sri Ravi Kumar, senior advocate, complainant submits that government has been giving repeated assurances to this court, ending with affidavit dated 24/7/2023, filed by the Deputy Secretary to the government. Stop. Sri Learned GA on instructions from Mr.
Secretary Dr. Venkatesh.
Joint Secretary Mr. So-and-so of Medical Education Department, that government does not stand by the said affidavit and seeks and is considering to file. What do you want to do? Considering to file a review petition before the Honorable Single Judge. Para 7 of the affidavit reads as follows. We may record that the accused is Mr. Naveen Raj Singh, IAS, Principal Secretary, Department of Health and Family. Is he the same incumbent officer now? IAS, full stop. But as on the date this affidavit was filed 24/7, was he the officer?
ಅದೆಲ್ಲ affidavit ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ transferred.
It is Javi that.
He was the officer. In fact, we have crossed that stage, para 11 of the order.
No, not that, sir. We are on little different. This is between us and between the
Very
court and the officer.
Very well.
They are treating the court like this. That is how that we are little picked about it. No, what we would like to know is, as on the date of filing,
Transaction transfer.
government officer filed. Full stop. As on it is stated in the affidavit that as on the date of filing the affidavit, the said officer was transferred. Full stop. According to the learned government advocate, Sri, what's his name?
Mohammed Moisi.
Mohammed Bardukodi, Mr. So-and-so IAS was the secretary. Now presently the same officer.
Javi that was.
That time Javed Akhtar, Mr. Javed Akhtar IAS was the secretary, and presently Mr. So-and-so is the secretary to the government. It is not understandable as to how a deputy secretary can file an affidavit on behalf of the accused and the subsequent officer can disown the undertaking given on behalf of the government. This is a serious matter. We direct the secretary to the government, Mr. So-and-so, to be present in court tomorrow, day after.
As also the director.
Who is the second? You have filed on behalf of both, is it? Who is the director?
Yes. But director.
Yes,
Director has recommended our case for regularization.
What I got to say?
We have only not recommended our case for the government to.
They are only recommending authorities. So he doesn't have much to do, sir. He has recommended and done his job. Mr. Malipatil says that
They're driving us from pillar to post. Government says you go to the director. Director group. Let him also be present before the court, because it is he who made the submission that regularization has been recommended and it will be done. And the government accepted it. Kindly see para 11.
Next line, Mr. Malipatil submits that the director A2 has already done his job by sending the recommendation. The same Sri Ravi Kumar submits that parties are being driven from pillar to post. Full stop. In the circumstances, we direct the director, A2 director also shall be present.
Please. Could it be on Thursday?
Day after tomorrow. Thursday, all right, Thursday.
Please, oblige.
Complaint? Yes, sir. What have you got to say?
That's like the orders for the presence of that.
What is the violation?
Conduct orient to the
Who is the ADL?
DDLR.
DDL.
You are the DDL.
DDL.
DDLR, what is your ranking, madam? You are an IAS officer. KS officer. We want to know, this has been 4th or the 5th or the 10th case. Why don't you comply with the orders of the court? No, not in this case. Generally, you are a revenue officer, correct? Or the Karnataka state cadre revenue officer. We want to know why the orders for change of khata, change in the name in ROR, Hodi and Durasti. Are you an assistant commissioner? Deputy commissioner. You are a KS officer, right? So what is your ranking if you are posted outside? Assistant commissioner? Oh, you are in the same department.
Yeah,
But why don't you do that? This Podi and Durasti, why you are not doing? We get repeated contempt cases. When will you complete this? Go get your file, read the file, come back, file an affidavit that on this day I will complete it. Is that clear? Don't you have the original order passed by this court? ತಮ್ಮ ಹತ್ರ ಇದೆ ಅಲ್ವಾ ಈ ಕೋರ್ಟ್ ಇಂದ ಆರ್ಡರ್ ಮಾಡಿರೋದು ಇದೇನೋ ಇಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ ಮತ್ತೆ ಆ ಆರ್ಡರ್ ಯಾಕೆ ಕೊಟ್ಟಿರ್ತಾರೆ ಹೇಳಿ ಈ ಕೋರ್ಟ್ ಇಂದ ಆರ್ಡರ್ ಯಾಕೆ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ
Well, we have to route through from Tahsildar.
then where is the Tahsildar? Why? ಬರಲ್ಲ ಅವ್ರು ಕೋರ್ಟ್ ಬರೋಷ್ಟಕ್ಕೆ ಸೌಜನ್ಯ ಇರಲ್ಲ. Who is the Tahsildar? Keep the Tahsildar present. Miss so and so ADLR submits that file is not received from the Tahsildar's office.
ಆಯ್ತು ಬರ್ಕೋತ
ಅದೇ ಅವ್ರು ಯಾರ ಹೆಸರು ಕೊಡಿ. Mr. so and so's office. Full stop. Who is accused number? Accused number 3.
A2.
ಅಲ್ಲ ತಾವು ಇರೋದು ಇವರು accused number 3 ನಾ ಇವಾಗ ಫೈಲ್ ಎಲ್ಲಿಂದ ಬರ್ಬೇಕು accused number 2 ಇಂದ ಬರ್ಬೇಕು
Accused number 2 is Anil Kumar Arlekar.
so according to her it has to come from Tahsildar. So Tahsildar is 2. According to the A3 file is not received from the Tahsildar A2. Full stop. Tahsildar is not present, directed to be present on Thursday. Both officers. In the meanwhile, if it is sorted out, fair enough. If it is not sorted out, we'll pass some strictures and orders. Please convey this.
190.
Affidavit who has filed? ಯಾರು ಹಾಕಿದ್ದೀರಾ ಸರ್ಕಾರಿ AG ಅವರೇ ತಾವು 18 ಆಯ್ತು 19
number 5 affidavit
ಅದೇನೋ ಸ್ವಲ್ಪ ರೆಕ್ಟಿಫೈ
Complaint
ಮಾಡಿ
ಇದೆ ನೋಡಿ,
ಸ್ವಲ್ಪ ರೆಕ್ಟಿಫೈ ಮಾಡಿ ಹಾ
It has been compliant.
ಅಲ್ಲಮ್ಮ
ಅದೇನೋ some compliance whoever have to do please do some compliance because there is a delay of 137 days some problem is yes compliance in 2 weeks
Committee has its proceedings in a C level. But I can publish it for last next year.
no you can't have access to that that's only even we don't want that you argue your case
They are a mere intermediary.
you are nothing to do in that
He is neither the creator.
all right pass it
The lordship has it.
sorry sir we are hard pressed for time we adjust our board what is this Mr. Solicitor General what he doesn't come you don't come he is there all right good. Complied no, reply by sir
We have issued 2 endorsement. Affidavit.
all
Reiterating the same reasons, which are stated not with other solutions.
so now we have to challenge that
And in that right, no direction was issued the law.
have you put it in writing
Yes.
then a matter has to be heard if you continue.
2019. It relies on the qualification prescribed in the year 2008.
All right. 19 March. Learned GA submits that counter has been filed all on 19 March.
Not to file complaints of the.
To file compliance.
Which
All
time it can.
All right. Shri Vachan seeks a week's time to file compliance affidavit. This 28 March. 6 times till 28th ಅಂತಾರೇಮೋ. ಇಲ್ಲ, ರಘುನಾಥ್ MD. ತಾವು ಇದ್ರಲ್ಲೇ ಇದ್ದೀರಾ? You represent the complainant. All right. All right. What acceptance of service of notice on A2? It's been served. For A2, Mr. So-and-so undertakes to file wakalatnama for on behalf of A2. Then police report, that's all done. Kiran
Yeah,
Alva is not in station. Hence,
A1,
proceed.
A3, A4, they have to file reply.
When will you file the reply? 2 weeks. Mr. Alva seeks 2 weeks time to file reply. 11 CCC. All right. 2 weeks, seeks 2 weeks time to.
There is a different case. There's nothing to do. No, it is not connected.
One nimsham. Seeks 2 weeks time to file counter. Granted. Full stop. Sri Mahendra's prays that the matter be listed along with CCC 1184 of 2023. As both matters are connected, the same is disputed by Mr. Alva. Post on 29/2/2023 consecutively, one after the other.
Parmeshwaraka?
PF etc. in 2 weeks. PF ಎಲ್ಲ ಕಟ್ಟಿ. ಇದರಲ್ಲಿ ಹ್ಯಾಂಡ್ ಗಿನ್ ಬರಲ್ಲ.
Contempt ಅಲ್ಲಿ.
ಕಂಟೆಂಪ್ಟ್ ಇಲ್ಲ, ಪೊಲೀಸರು ಹೋಗ್ಬೇಕು, ಇಲ್ಲ ಪೋಸ್ಟಲ್ ಹೋಗ್ಬೇಕು ಅಲ್ವಾ? Yeah, paid process. All right. Submits that needful is done, office to verify and issue notice. PF etc. Abhishek. Which university?
Vice Chancellor.
Withdraw is- What is the order? You are complying.
Sometimes we are tendering, whatever the demand made by the.
What would you? One copy code.
Petition statement filed.
You are happy?
Memo filed. Memo filed.
Money received? Is it demand draft or what?
Yes.
Total amount?
Yes.
All right, 230. Note ಬಂದು ಕಂಪ್ಲೈ ಆಗಿದೆಯಾ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಕು. Pass out.
And they permitted to file.
Wakalat and photocopy of that.
Copy that.
All. Pass over 230.
Right, to file it in the court matter.
ಎರಡೂವರೆಗೆ ಬನ್ನಿ ಯಜಮಾನ್ರೆ.
Apply.
Complied. Mr. Sampath submits that the 27 complied. Submits that order has been complied. CCC closed. Submission placed on record. Yes, 28.
My lords, I appear for accused number 1 and 2, my lords.
Yes.
I undertake to file the wakalat today by the end of the day. A short date
One
may
and-
be given for me. May be given for me to file the compliance affidavit, my lords.
All right. Mr. So-and-so undertakes to file wakalatnama on behalf of accused 1 and 2. Only 2 accused?
Yes, my lords.
All right. And seeks 4 weeks time to file counter granted.
Grateful, my lords.
On rest all, what is this so much of miscellaneous?
Office not to be deleted.
On filing of reply all. Yes, office, entire office note be deleted. Next.
Lord, serial number 29.
Yes.
So this is the batch pertaining to the applicability of the PTCL Amendment Act.
All those have been adjourned.
Lord,
Morning.
well, one difficulty in one matter, 938, in which I am appearing, my lord. There's a stay in all the other matters, my lord. In this, my lord, stay applications pending. Your lordships may kindly direct stay to be granted in the.
It can't be because at 10:30 mentioning was done. So it has gone. It will come on an appropriate date. On that date, kindly make your submission, sir. Thank you.
Lordship, give a date, my lord, may I request? I'm so sorry, will your lordships.
Which date? Please find out from the court officer at the end at 1:30.
Please.
All right. Thank you.
Thank you.
What is this? What is the matter?
Gandhi Bazar case. Road widening.
File it. First point, please tell us, how can court regulate where there should be footpath? We will not, please understand, we are asking you one question. You are a lawyer.
There was pretty reported plan. The road width was supposed to be about 10 meters. Then thereafter, they changed it to 9 meters.
So you are a lawyer, please follow this. What is In this,
It's very petition. And
you challenged it before the apex court.
Apex court. That is one aspect of it. Against the release of the iron works are concerned, we have filed RP also, which is also pending before the honorable apex court, which is likely to come up within 10 days. The SLP number, diary number is given. SLP number is given, 3585. No, 3586 of 26 or 24.
But Mr. Aditya Narayan, in the teeth of the submission, how can we pass it
Well,
on?
may I only say this in the future? Look, your lordships, in October, on the 4th of October, permitted me to sell it by privately. Then, my lords, I entered into an export contract. They gave me the permits pursuant to that order. Ultimately, only one permit was not given. I came back to your lordships in December, your lordships, asked a further order to sort it out. Despite that, it is not done. Now, my lord, having accepted the order, how can they now challenge it? Because ultimately, those orders have worked themselves out, the auction has failed.
That is the beauty of this profession.
But look, the difficulty is this, now I have a purchase order from another buyer. That is also time bound.
No,
Every time, my lords, if they
no,
frustrate the same.
we appreciate it
There
on,
is no same.
we appreciate the contentions on both sides, but please tell us, in this fact and circumstance, how can we pass any on?
No same, my respectful submissions, your lordship stands. There is no same, your lordship orders.
We made our endeavor to get it listed before they handle listed.
See,
For 2 years, my lord, we
Learned-
are waiting to move this forward. Every day, my lord, the.
Learned Government Advocate submits that the interim order dated, which you have challenged before SLP.
14/12/23.
14/12,
10th of October, my lord.
4/10/2000.
4/10 ಒಂದಾಗಿದೆ, ಇದು ಎರಡಾಗಿದೆ.
ಯಾವ್ದನ್ನ ತಾವು SLP ಲಿ ಯಾವ್ದು ಇಂಪ್ಯೂನ್ ಮಾಡಿದೀರಾ?
The order dated 4/10/2020.
Order dated 4/10/2023 in SLP number
SLP number 3585 to 3586 of 2000.
ಬರೆದು ಕೊಡಿ. In SLP number such and such. Full stop. Shri Aditya, next line, Shri Aditya Narayan submits that there is no interim order and no interim order has been passed by the apex court. Sorry, he got it. Since there is no stay order from the apex court, this court may may issue further directions to the appellant, to the respondents. Full stop. That Government Advocate submits that the SLP is likely to be listed within, is listed shortly. Full stop. On 6th March.
My lord, my current PO required me to perform. by the
28
end of
February. 28 February.
the-
Thank you.
We have for every second, so because 10 days, my lord, is. But the difficulty is, this opportunity I use, my lord. 3
Mr.
times.
Aditya Narayan, we have been requesting you since at from 10:30.
I see.
Thank you.
Great.
Now for the, for 7. Second set.
Do whatever, there is none for the petitioner
Sure. That's right.
for compliance in 2 weeks. Yes, next, Marcel did.
They request that I file my memo of appearance.
Whatever you want to do, kindly do that.
I filed.
Your file, get it listed. Thank you.
After the in-camera hearing for more than half an hour, the call was filed by both the father and the mother, and I will indicate the reason. So Monday to Thursday, the father will have. And Saturday, the back leg will have.
What order are you challenge, what order are you complaining of?
Because all of us, the right to fight with the party, at page number 53.
Violation of terms of joint memo.
One day the mother complained, the dictation that I want to go.
That where have you filed the compromise? Before the family court.
No.
Family court can enforce it. That's the law. That's a different matter.
Now, for 1 month, I have not seen my child.
No, that's one thing. That's fact of the matter today remains that you see the court, family court has enough and more teeth and power. Correct.
Implementation of the order, but for violating the order of the court.
It's not violation. It is a kind of parties agree.
Order is based on the undertaking.
Yes, why don't you do that, Mr.?
But they submit my objections, madam.
What objection?
My objections to the petition, to the contempt petition.
No, prima facie, what have you got to say? We are,
My submission is that on 10th, this joint memo comes to be agreed upon between myself and the complainant party. And on 11th, it was complained with, but on 12th, my child fell sick. And she also, she was diagnosed with rhinitis. That about,
your husband or wife?
I'm the wife. I'm the wife. The child is a 7-year-old girl child and she is in my custody as of now. But that apart, if the joint memo maybe taken a look at, it is in such a fashion, it has been written in such a fashion that after school hours from Monday to Thursday, the child will be taken.
Then why don't you now comply it now at least? Now the
As of now, my lord, the another constraint I'm having here is that the child is not agreeing to be in custody, shared custody of the father. My lord, as far as visitation goes,
then go back to that court, seek a modification.
we filed necessary applications before the trial court in this regard.
Where have you filed?
Before the 5th additional family judge, we've filed.
Already filed. You have served a copy on them.
Yes, sir.
Have you?
The application.
Yeah, application.
Injunction for the father not to take away the custody from the mother. I don't want to take the custody, I only want visitation. That order has already been passed to the family court.
Where is that modification application?
Well, it's not a modification. We have, the application that I filed was with regard to interim custody throughout the proceedings. It was not. Well, visitation, even I have no objections, my lord.
Then please do that. That's all.
We will approach the my lord, we will approach the family judge and.
No, Mr. Visitation, if you have no problem, he doesn't want the custody. He wants to visit the child. Facilitate it. Problem is solved.
Well, the joint memo.
No, the memo says that you will visit the girl.
The child in the school, spend time for 3 hours, and then drop it to the mother's place.
My lord.
Why don't you comply with that?
My lord, the distance here matters, my lord. If we comply with that particular joint memo, the child is expected to travel around 30 kilometers in a day, in a single day, my lord. The father's residence is located 16 to 17 kilometers away from the school. And now for the convenience of the child, I have rented a space near that is within 1 kilometer radius of the school. If I were to comply with the joint memo, I will be asking my child to travel around.
ಮಾಮೂಲಿ ಇದು ಏನೋ ಪ್ರಾಬ್ಲಮ್ ಇದೆ Them go before the family judge himself.
Sir, but
My lord, I have no objection for the father to come down to my residence and visit the child and spend time with the child in a common place within my
you
apartment.
start with that. That way. We have to seek modifications, sir. We can't now do anything at this point of time.
I mean, see my parents, the child has been brought up by me, she's been working, I stay at home. I don't have any job. That's the complete share, left me, I don't have any employment. I stay at home. She works from 7 in the morning to 7 in the night.
My lord, that part.
Some access, lordship are going to all cases head. The parental discord should not result in the child losing out access to one parent.
We continue to hold that opinion.
Some
What do you want us to do?
The order is, we to keep the child in the school.
No, but we can't modify that order.
That's why the mother stays now 2 kilometers from the school. My house is 3 kilometers from the school. I pick the child and I drop all the child to the mother's place and send it immediately.
Mother is staying 2 kilometers.
2 kilometers, I stay 1 kilometer away from mother's house. She's moved to Hebbal, but after the petition was filed, she moved to Hebbal. I stay on Palace Road.
Hebbal to Palace Road is how much?
About 2 kilometers.
That's all.
No, on that Palace Road, I stay on an apartment on Palace. Just 2 kilometers.
My lord,
Mister, do one thing, comply with that order. Don't deprive father of meeting the
My lord,
client.
I am not depriving of the father.
He will not come to your house if you have already agreed on this. See, till such time you get your order modified, keep complying the order. That's all.
My lord,
If you want to get it modified in the before the family court. No problem. Is that clear?
I have
Otherwise, leave the child. Bring the child here. We will give the custody to him.
My lord, because,
Mister, there is nothing more. We are very, very clear. Whatever that the parties agree before the court, they must, letter and spirit, they must follow. Number one. Number two, if they want modification, they must seek modification in accordance with law. Full stop. Don't keep on repeating the same arguments. We are not inclined, we are not impressed by that. So you have an option. You want to change the order, go to the appropriate court. You can do that. Till such time, follow this order. We'll call it on Thursday. See, if you don't follow it, then you see we'll have to issue appropriate some harsh orders. Thursday. In the meanwhile, as an officer, learned advocate, as an officer of the court, we are telling you don't get into the shoes of the parties. As officer of the court, be very objective in these matters and advise your client and do the needful. All right. Thank you.
Okay.
What is the office objection?
The respondent of both has been made as a person or party. They say, why do you want to make them as a party? First, I will delete them as access the party.
You want to delete
Yes.
all. Learned advocate seeks leave to, has filed a memo seeking leave to delete R4, accused number 4. Leave granted, permitted. Please do the need.
First and it's against responding to accused number 1 and 2.
What is the violation?
The violation here is that they have to consider a representation within 8 months. Regard to a promotion. That there to find that page number 32 not been done. In spite of 2-3 remind.
What is it? What have you written in that representation?
But the representation is that let's could consider me.
What is that? What is the prayer in your representation?
The representation is not a part of this it's a representation to us.
Regarding their promotion.
The representation is to consider
Well, chief of
for promotion in terms of a seniority list.
So even that document is not before the court. How can we appreciate it? Please file that document at least. The advocate for the complainant submit that the representation complainants. Your complainants is it?
Complainants.
What is the prayer final in that representation? Page number, para. Their request made in the representation for promotion has not been considered. Notice. You can take notice for 3 AG, learned AG. And AG accepts notice for 3, notice to 1 and 2. There.
Now the development is that with regard to the technology, illuminated LED laser systems they are using. A lot of the time we have filed the petition in the before the honorable speaker did that in the order approved in the page number 34.
What is this? What is the prayer?
Yeah, given the representation is not considered till today.
What is that you have made? What is the request made in the representation?
A ban on net billboard and motion picture displays of advertisements alone.
Why, sir? Why it should be banned?
Advertisement bylaw is there, rules in the BDM. That too, that been formed in the year 2006. Then it is modified 2018 and 19.
By virtue of which, what happens?
By virtue of the no motion pictures has to be given. The only still photograph has to be. Nowadays it is all in started in all the gold and jewelry shops and also in the malls. Just like a film, they are putting effect to the photo and also the brightness,
Photo sensitivity.
photosensitivity and also light. I have find some research letters also. These are the.
What is the office objection and what is the counsel for
Yeah, one, the letter given by the.
translated copies? You'll file it.
I will translate.
Shri Amritesh seeks 2 weeks time to file the translated copy of Annexure F. Heard notice. 1, 4 and 5. Letter J accepts notice for 1, 4 and 5. Mr. So and so accepts notice for 2. You will take for VBMP also. 2 and 3. You may have clash of interests.
Then that's a respondent number 2.
Respondent number 2. Who is for the VBMP? Any lawyer for VBMP? Mr. Keshav Datar. All right. Keshav Datar for respondent number. Is directed to take notice for respondent number 3. That's right. We have issued notice.
Day and night, in the circle also they are flashing this.
All right. It's 6 times sought granted March 7. IA4 for impleading. Who has filed?
I have filed.
You have filed. Any objection? You have objection for that IA? Allowed, all right. Learned applicant, learned advocate for the appellant. Oh, why they are in? Oh, in the appeal. How can you come in appeal? Or you party in the original proceeding?
Their party before the learned single judgment.
Respondents? Right. 4 and 6. Who are the applicants?
A lot of respondent 4 and 6 members. I am representing respondent number 3 to.
No, when did respondent number 4 die?
In the pendency of writ petition.
Legal representative is not brought. What about 6?
It also matter. 1 and 6.
What is the matter about?
Respondent number 4 died on.
So what is the matter about LABD and land acquisition? Is it?
Gavippuram ನೋಡಿ ಇವರು ಎಲ್ಲರೂ ಸಿನಿಮಾಲ మనం
All right. Barkoli. This application is filed by the legal representatives of
R4 and 6
deceased respondent number 4 and 6. According to your Mr. Balkrishna. Sri Balkrishna submit according to the Sri Balkrishna for the applicant submitted that the legal representatives of applicants who are the legal representatives were not brought on record by the appellant. Applicant for legal representatives of respondents number 4 and 6 have not been brought on record. Hence
ಅವರೇ
this
volunteer
application. Hence this application. Full stop. Learned advocate, you are appearing for the BDA, is it? BBMP. Learned advocate for the appellant has no objection. In substance, this IA is a substitution application for deceased respondents number 4 and 6. The necessary parties application allowed. Amendment 4th with Ivagle Mat. Mateno? Applicants as R4A and R6A and F.
A to F.
Correct. Then IA4 shall be considered at the time of final hearing. Yes, Vinayak Vishnu Bhatta. All right.
ನೀವು ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕು ನೀವು BBMP ಅವರು.
Amendment ಮಾಡ್ಲಿ ಅವರು. So, ಎಷ್ಟು?
12th March.
12th March ಅದರ ವೀಕ್ ಫುಲ್ ಆಗಿದ್ದಾರೆ.
Shortest date on the
ಈ ಮಂತ್ ಅಲ್ಲಿ ಆಗದೆ. ಆಯ್ತು 12th March. Correct. Thank you. Yes, next. Vinayaka B. Vishnu Bhatta. What is this vacating stay? Labor matter. They have filed the application. Appear for state. Who has filed this application? IA2 of 20. Oh. He has filed the application. Applicant order on IA1 of 23. Sorry, ಏನು ಬೇಡ ಸುಮ್ಮನೆ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಬರ್ಬೋದು. Applicant's advocate in IA2 of 23, Sri Anantram, TP Anantram has passed away. All after 4 weeks on date for interim order extended.
41.
Yes. What is this? What is the stay? What is the stay for? You are defendant. How much money he had to pay? 24 lakhs. So now what is the application?
Statement of objection.
That has to be heard.
ಇವ್ರು ಅಡಿಷನಲ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಆಗಿ ಹೈಕೋರ್ಟ್ ಮಾಡ್ತಾರೆ 4ನೇ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಇವ್ರು ಪ್ರಾಪರ್ಟಿನ ಸೇಲ್ ಮಾಡಕ್ಕೆ ಹೈಕೋರ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಬೇಕು. ಇವರು ಅಲ್ಲಿ ಈ ಡಬಲ್ ಬೆಂಚ್ ಅಲ್ಲಿ 2 ಸಾರಿ ಆರ್ಡರ್ ಮಾಡಿದೆ ಈ ಸೆಲ್ಫ್ ಡಿಪಾಸಿಟೆಡ್ ಮಾಡಿಲ್ಲ. ಆಮೇಲೆ ಇವ್ರು ಏನ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ದುಡ್ಡ ರಿಲೀಸ್ ಮಾಡ್ತಾರೆ ಅಂತ ಖಂಡಿತ ಇಲ್ಲ. ಪೇಜ್ ನಂಬರ್ 76 ಅಲ್ಲಿ ಇವ್ರು 4 ಮೆಮೊ ಕೊಟ್ಟಿದ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಬನ್ನಿ ಅಂತ ಕರೆದಿರೋದು. ಆರ್ಗ್ಯುಮೆಂಟ್ ಬರ್ದೇನೆ
ಇಲ್ಲ ಅದೆಲ್ಲ ಮುಂದೆ ತಾವು
ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು. ಯಾವುದು ಪೇಜ್ ನಂಬರ್ 7
ನೀವು ನರಸಿಂಹಯ್ಯನ ನಿಮ್ಗೆ ಅವರು ಎಷ್ಟು ದುಡ್ಡು ಕೊಡ್ಬೇಕು?
12 ವಾರ 2003 to 2008 ಕೊಡಬೇಕು 9%.
ತಂದೆ ನಾವು ರನ್ ಮಾಡ್ತಾ ಇದ್ದ MD ನಾವು ಸೇರ್ಕೊಂಡು ಬೈಂಡಿಂಗ್ ಅಗ್ರಿಮೆಂಟ್ ಫೈನಾನ್ಸ್ ಎಲ್ಲ ತಗೊಂಡು ಸತ್ತೋದ್ಮೇಲೆ ಇವ್ರ ಅಣ್ಣ ನಾನೇ ಮನೆಗೆ ದೊಡ್ಡವನು ನಾನೇ ಎಲ್ಲಾರು ಕೊಡ್ತೀನಿ ಅಂತ ಹಾಕಿದ್ರು. ಆಮೇಲೆ ಇವ್ರ ತಾಯಿ ಇವ್ರ ಮನೇಲೆ ಸತ್ತೋದ್ಬೇಕ. ಇವ್ ಇನ್ನೊಬ್ಬ ತಮ್ಮ ಡಾಕ್ಟ್ರು ಅವ್ನ ಮನೇಲಿ ಸತ್ತೋದ ಅವ್ರಿಗೂ ಅನುಭವಿಸ್ತಾವ್ರೆ. ಅದರಿಂದ ನಾನು ಬಡವ
ಅಗ್ರಿಮೆಂಟ್ ಮೇಲೆ
ನನ್ನ ಜೀವನ ಮಾಡಕ್ಕಾಗಲ್ಲ, ನನ್ಗೆ ಕನ್ಸೆಷನ್ ಕೊಡಿ ಅಂತ 3ನೇ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ನ ರಿಜೆಕ್ಟ್ ಮಾಡಕ್ಕೆ ಅದು ಇನ್ನು ಪೆಂಡಿಂಗ್ ಅಲ್ಲೇ ಇದೆ. ಅದಕ್ಕೆ ಇವ್ರು ಬಂದ್ರು ಇನ್ನೊಬ್ರು ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ರೆ ಅಲ್ಲಿ ಕಾಸ್ಟ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ
ಸಫರ್ಡ್ ಡಿಗ್ರಿ ವಾಟ್ ಕ್ಯಾನ್ ಬಿ ಡನ್?
ಈ 2 ಲಕ್ಷ ಏನೋ ಕೊಡ್ಬೇಕಷ್ಟೇ.
On what ground?
Subsequently, our friend, our contention is that the partnership deed was without partial, yet he has not disclosed it. Without disclosing, is not allowed to take a misrepresentation of action.
Have you, how much is the total decree for?
The amount was 4 lakh, 8
Sir,
lakh,
it's always with interest.
8 lakhs.
How much it comes to today? ಅಷ್ಟೆಲ್ಲ ಡೀಟೇಲ್ ಬೇಡ, ಟೋಟಲ್ ಅಮೌಂಟ್ ಹೇಳಿ.
4 lakhs. 4 lakh, as of 28/11/2023, when I deposited something like that.
How much money have you deposited?
18 lakh, 92,218.
Then deposit,
Other date tax deposit 8 lakhs and that is transport and there is also withdrawal by you.
so totally you have deposited 26 lakhs, is it?
24 lakhs 74,218.
80 ಲಕ್ಷ ಸಂಪಾದನೆ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಕೋರ್ಟ್ ಸೇಲ್ ಮಾಡಿದ್ರು ಸರ್, ಪ್ರಾಪರ್ಟಿ ಅಲ್ಲಿ ಸೇಲ್
ಅಲ್ಲ,
ಮಾಡಿ
ಇರ್ಬೋದು, ತಮಗ್ ಬರ್ಬೇಕಾಗಿರೋ ದುಡ್ಡು 24 ಲಕ್ಷ ಮಾತ್ರ.
ಇಲ್ಲ ಸರ್.
ಆಮೇಲೆ 2%
ಮೆಮೋ ಹಾಕಿದ್ದೀನಿ ಸರ್. ಅದು 18 ಲಕ್ಷದಲ್ಲಿ 2 ಭಾಗ ಮಾಡಿದ್ದಾರೆ. ನನ್ನ ಮಾಡಕ್ಕೆ ಹೊಸ ಜಡ್ಜಸ್ ಬಂದ್ರೆ, ಹೊಸ ಕೋರ್ಟಲ್ಲಿ ಬಂದ್ರೆ ಹೊಸ ಅಫಿಡವಿಟ್ ಧೈರ್ಯವಾಗಿ ಇಲ್ಲೂ ಕೂಡ ಇರ್ತಾರೆ. ಎಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ
ಅಲ್ಲ ನೋಡಿ, ಡಿಗ್ರಿ ಎಷ್ಟು ಅಮೌಂಟ್ ಇದೆ?
ಹೈಕೋರ್ಟ್ ಡೇ ಬೈ ಡೇ ಮಾಡಿ 1 ವರ್ಷ 7 ಜನ ಜಡ್ಜ್ಗಳು ಸೈನ್ ಮಾಡಿ ಡಿಸೈಡ್ ಮಾಡಿದರೆ 1/4 8 ಲಕ್ಷ ಅಂತ. ಅವನ್ನ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡುವಂತ ಹಂಗೆ ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ. ಇವ್ರು ಅಟೆಂಡ್
ಈಗ ತಮ್ಗೆ ಎಷ್ಟು ಬರ್ಬೇಕು ಒಟ್ಟು ಈಗ ಹೇಳಿ. ಇವತ್ತು ನಮ್ಮ ಎಷ್ಟು ಅಮೌಂಟ್ ಹೇಳ್ಬೇಕು ಬಾಯಲ್ಲಿ?
32 lakhs ಸರ್.
32 ಲಕ್ಷ ನೋಡಿ.
ಮೊನ್ನೆ ಈ
Actually, our execution is not 8 lakhs.
ಕೋರ್ಟ್ ಡಿಸೈಡ್ ಮಾಡಿ
ಕಟ್ಟಿ ಡೆಪಾಸಿಟ್ ದಿ ಅಮೌಂಟ್.
Plus 5% sale value, sale with property. Other up to 5% that amount to like 24.
Why it has come today for vacating the stage?
ಇವರೇ ಮಾಡಿದ ಸರ್.
ಹೌದು, 2000 ನೋಡಿ, 2024 ಅಪೀಲು ಇವಾಗ ಸ್ಟೇ ವೆಕೇಟ್ ಮಾಡ್ಬಿಟ್ರೆ ಏನ್ ಉಳಿಯುತ್ತೆ ಅದ್ರಲ್ಲಿ?
ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ, ಯಾರು ಬಡ್ಡಿ ಬರಲ್ಲ, ಏನಿಲ್ಲ. ನಾನು ಹಾಸ್ಪಿಟಲ್ ಅಡ್ಮಿಟ್ ಆಗಿದ್ದಂತ ಬಂದ್ರು, ಇವೇ ಕೊಟ್ಬಿಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ.
ತೋರ್ಸಿ ಅಫಿಡವಿಟ್ ತೋರ್ಸಿ ಅಫಿಡವಿಟ್ ತೋರ್ಸಿ.
ಒಂದ್ ಸೆಕೆಂಡ್ ಪೇಜ್ ನಂಬರ್ 77 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ ಸರ್.
ಪೇಜ್ ನಂಬರ್ 77.
14 ಅಲ್ಲಿ ಇದೆ ಸರ್. ಇವ್ರು ಹಾಕಿರೋ
ಯಾವ 77 ಆಫ್ ವಾಟ್?
ಸರ್ ಪೇಜ್ ನಂಬರ್ 7 ಸರ್. ನಾನು
ಪೇಜ್ ನಂಬರ್ 7 ಆಫ್ ವಾಟ್?
ಪೇಜ್ ನಂಬರ್ 7 ನಲ್ಲಿ
8 ಲಕ್ಷ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ರಿಮೈನಿಂಗ್ 25% ಡೆಪಾಸಿಟ್ ಮಾಡಬೇಕು. ಅದನ್ನ ಇವರಿಗೆ ರಿಲೀಸ್ ಆರ್ಡರ್ ಆಗಿದೆ. ಮಾಡಿದ್ರೆ ಮುಗಿತು. ನೀವು ಆ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ಡೆಪಾಸಿಟ್ ದಿ ಅಮೌಂಟ್.
ಮಾಡಿಲ್ಲ
Authority not is for freedom of objections to the
ಸರ್. ಇವರು ಇಲ್ಲಿ ಎಲ್ಲಿ
ನೋಡಿ, ಇಬ್ರು ಫ್ಯಾಕ್ಟ್ಸ್ ಕರೆಕ್ಟ್ ಹೇಳಲ್ಲ, ಏನ್ ಮಾಡೋದು? cannot deal with that.
ಸರ್ ಇರೋ ದುಡ್ಡು ಕಟ್ಟಿದ್ದಾರೆ, 2 ಲಕ್ಷಕ್ಕೆ ತಗೊಂಡು ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ದುಡ್ಡು ರಿಲೀಸ್ ಮಾಡಿ ಇವ್ರೇ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದಾರೆ. ಇಲ್ಲಿದೆ
ಅದು ತೋರ್ಸೋದು ಇಲ್ಲ. ನೀವು ಯಾವ್ದೋ ಒಂದು ಪೇಜ್ ನಂಬರ್ ಹೇಳ್ತೀರಾ, ಇದ್ರಲ್ಲಿ ಇರಲ್ಲ. ನಿಮ್ ಕನ್ನಡಕ ಇಲ್ಲ ಅಂದ್ರೆ ನಾವ್ ಏನ್ ಮಾಡೋದು? ಕೊಳ್ಳಲ್ಲಿ ಹಾಕೊಂಡಿದ್ದೀರಾ, ಮುರಿದೋಗ್ಬಿಟ್ಟಿದಲ್ವಾ? ಇನ್ನೊಂದ್ ದಿವಸ ಆಯ್ತು, ಹೊಸದ್ ಕನ್ನಡಕ ತಗೊಂಡು ದಯವಿಟ್ಟು ಇನ್ನೊಂದ್ ದಿವಸ ಬನ್ನಿ, ಅವತ್ತೆಲ್ಲ ಕೇಳ.
ನೀವು ಹೋಗ್ಬಿಟ್ರೆ ನನ್ ಕೇಸ್ ತಪ್ಪಲೇ ಆಗ್ತದೆ ಸರ್. ಸರ್ ಇವ್ರು ಏನೇನಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ. ಇವ್ರು ಹೇಳಿದ್ದಾರೆ ನೋಡಿ ಸರ್, ಇಲ್ಲಿದೆ. ನನ್ಗೆ
ಪೇಜ್ ನಂಬರ್ ಹೇಳಿದ್ರೆ ತೆಗೆದು ಓದ್ಬೋದು.
ಪೇಜ್ ನಂಬರ್ 7
ಅಪ್ವಾರ್ಡ್ ನಾವು 3 ಸತಿ ಕೇಳಿದ್ವಿ.
5 ರಿಪಿಟಿಷನ್.
ಅದ್ ಕೊಡಿ, ಅದ್ ಕೊಡಿ, ನಿಮ್ದೇ ಪೇಪರ್ ಕೊಡಿ. ಒಂದ್ ನಿಮಿಷ ನೋಡಿ ಸರ್, ಜೀವನ
ಒಬ್ಬರೇ ಈ ತರ ಕೊಡೋದು 5 ಜನ
ಹೇಳಿ.
ಕೊಡಿ ಅಂತ ಬರ್ತಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ ಅದನ್ನ? ಆ ಲೈನ್ ತೋರಿಸಿ, ಅದನ್ನ ದುಡ್ಡು ಕೊಡಿ ಅಂತ ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ.
ಇದಾದ್ಮೇಲೆ
ನೋಡಿ, ಆ ಲೈನ್ ಸ್ವಲ್ಪ ಮಾರ್ಕ್ ಮಾಡಿ ಕೊಟ್ರೆ ಓದ್ಬಹುದಲ್ವಾ? ನಿಮ್ ಕನ್ನಡಕ ಬೇರೆ ಇಲ್ಲ ಇವತ್ತು.
ಎರಡು ನಿಮಿಷ ಪರ್ಮಿಷನ್ ಕೊಡೋಣ ಬರ್ಕೊಂಬಂದಿ ಸರ್.
ಹೇಳಿ. Listen, please wait for a minute.
14% ಇದೆ, ಯಾಕೆ ನೀವು ಪೆನೆಟ್ರೇಟ್ ಮಾಡ್ತೀರ ಅವ್ರು?
ನೋಡಿ, ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, ದಯವಿಟ್ಟು ನೀವು ಏನೇನ್ ನಮ್ಗೆ ಇಷ್ಟೇ ಬೇಕು ಇಲ್ಲಿ ಕೇಳಿ. ನಾವು ಹೇಳೋದನ್ನ ಒಂದ್ ನಿಮಿಷ ನಾವು ಹೇಳೋದನ್ನ ಕೇಳಿ. ನಿಮಗೆ ಟೋಟಲ್ ದುಡ್ಡು ಎಷ್ಟು ಬರಬೇಕು? ಪಾಯಿಂಟ್ 1 ನಂಬರ್ ಪೂರ್ತಿ ಕೇಳಿ. ನಂಬರ್ 2, ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಷ್ಟು ಎಂಟ್ರಿ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ನಂಬರ್ 3, ಅವರು ಈ ದುಡ್ಡು ತಾವು ತಗೊಳ್ಬಹುದು ಅಂತ ಎಲ್ಲಿ ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ ಅನ್ನೋದು ಅಫಿಡೇವಿಟ್. ಈ 3 ಪಾಯಿಂಟ್ ಅನ್ನ ತಗೊಂಡು ಬೇಕಾದ್ರೆ 2:30 ಬನ್ನಿ, ಇಲ್ಲ ನಾಳೆ ಬನ್ನಿ, ಕೇಳ್ಬಿಟ್ಟು ಮಾಡ್ತೀವಿ. ನಾಳೆಗೆ ಹಾಕೋಣ. ನಾಳೆಗೆ ಬನ್ನಿ. ಇದು 3 ಪಾಯಿಂಟ್ ನೋಡ್ಕೊಂಡು ಬನ್ನಿ.
ನಾಳೆಗೆ ಏನ್
ನಾಳೆ ಚೇಂಜ್ ಆಗಲ್ಲ. ಇನ್ನು 23ನೇ ತಾರೀಕು
ಇಂದಿನ ಆಫರ್ ಕೊಡ್ತೀನಿ. ನಾನು ಸರ್ವಿಸ್ ಮಾಡಕ್ ಹೋಗಿರೋದು 20 ಬಸ್ ಓಡ್ಸಕ್ ಹೋಗ್ಬಿಟ್ಟು ಸರ್ವಿಸ್.
ಆಯ್ತು, ನಾಳೆ ಬೆಳಿಗ್ಗೆ ಬನ್ನಿ. ನಾಳೆ ನೋಡಿ ಬರ್ದು ಕೊಡ್ತೇವೆ. ನಾಳೆ ಇದು 3 ಪಾಯಿಂಟ್ ತಗೊಂಡ್ ಬನ್ನಿ ಅಷ್ಟೇ. ಎಲ್ಲ ಫೋಟೋ ಕಾಪಿ ಮಾಡಿಸಿ. ಥ್ಯಾಂಕ್ ಯು. Yes, please. What is the application?
ಕೋರ್ಟ್ ಫೀ ಕೊಡೋದಕ್ಕೆ ಡಿಸ್ಪೆನ್ಸ್ ಕೇಳ್ತಾರೆ, ಕೊಡಕ್ಕೆಲ್ಲ ಕೊಡಲ್ಲ. ಕೋರ್ಟ್ ಫೀ ಕೊಡೋದಕ್ಕೆ they are asking for dispensation of payment of court fee.
Court fee has been paid? Yes. Court fee has been paid.
DNP.
Court fee has been paid. IA1 you are not pressing, is it? IA1 of 24 is not pressed, dismissed. IA2 is dispensed production of certified copy. You have not got, all right. IA2 allowed dispensation ordered for 3 months. Then IA3 is for CD. What I got to say for delay? All right.
Already they paid 8 lakh rupees for the balance amount. They said 2 months time they want.
Independent expert remand ಆಗೋಕ್ಕೆ
Directly transfer the account of the respondent. I find petition.
he has appeared through advocate, he has not
Return statement, is that correct? Shall we send them?
But they are not to file the letter.
Shall we remand the matter on some terms? How much cost you want? No, sir, not like that. See, it will be easy. No problem, we'll give you time, but you can also inform, if you like, if it remains here, if the COMAP is admitted and kept, it's a recovery, is it?
recover.
Money recovery.
Non-laksha.
So after 5 years, if it comes, money value will be almost 0. If you get the matter adjudicated, you will get some costs, isn't it? Come back at 2:30 and tell us, telephone and to find out how much cost you want. We'll close the matter. All right? 2:30.
This is regarding appointment of the presiding officer for PGIT.
ಏನು PIL ಏನ್ ಮಾಡಿದೀರಾ?
The search committee headed by Honorable Justice has met on 6th February and candidates have been shortlisted. The list has been.
When can you do approximately?
The list has been sent to the IG.
Approximately, when can you do? Approximately, sir, 6 months. ಅವ್ರಿಗೆ ತುಂಬಾ ಕಷ್ಟ ಆಗುತ್ತೆ.
There is a process. The IG generally takes. But after the IG sends, the search committee has to sit again.
ಇದು ಯಾವಾಗ್ಲೂ ತಾವು ಒಂದು you will be knowing ನಿಮ್ಮ ಹತ್ರ now everything is on computer. You must start doing this process little earlier.
Every effort has been made.
ಲಕ್ಷ ಕಟ್ಟಬೇಕು ಇವರು ಅಂತ. ರಿಟ್ ಪಿಟಿಷನ್ ಹಲವಾಗಿ ಇವ್ರು ಏನ್ ಮಾಡಿದ್ರು, ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಯ್ತು ಅಂತ ಹೇಳಿ.
You appointed and withdrew that order. You said compliance is done in this court. then you withdrew that order.
Earlier the law.
So,
ಕ್ಲಿಯರ್ ಆಗಿ ಇದು PL ಡಿಸ್ಪೋಸಲ್ ಆಗಿ ರಿಓಪನ್ ಆಗಿರೋ ಕೇಸ್ ಇದು.
The original vacancy was created in January 2021. About a couple of months prior to that.
so what should happen to workmen, sir?
Let me explain what has happened.
The Solicitor General can very comfortably say, the Secretary Government can all, yes, 21, 22. Why don't you bear with us? We are asking you a question. 2021, your secretary is sitting in the air conditioning. 22. What should
We circulated for the candidature. In the meantime, the rules for appointment were challenged before the Honorable Supreme Court. When the rules were pending on, eventually it was struck down, which led to the government passing the ordinance, namely the Tribunal Reforms Act 2021. That was issued only in July 2021. Thereafter, the search committee met. It selected a candidate, namely one Mr. Nagaratna. She was, her name was, a proposal was sent to the appointments committee. It was approved. She was directed to take charge. In the end, she says, I'm not going to take charge. So therefore, we have to start the process all over again. We started the process all over again. The search committee met again with a new head then, and then names were sent for about 9 tribunals. The names for 6 tribunals were accepted. Unfortunately, Bangalore's nomination was not accepted by the central government. So therefore, we started the process all over again. Now, there is a new search committee headed by.
So when will you complete the entire process?
Now, the search committee has met. The candidates have been shortlisted. It has been sent to the IB. Maybe about 4 months. We'll try to complete it. It's upper limit of it. Because there is an appointments committee headed by the Honorable Prime Minister and the Home Minister. Therefore, it may require some time. Within an outer limit of 4 months.
7 names were recommended in
Correct. We agree with you. But the point is, supposing at this point of time, Solicitor General is coming with a proposition. He was up to 6 months. Now he is slowly reducing it to 4 months. What further? ಆಯ್ತು ಇವಾಗ ಅಲ್ಲ ಇವಾಗ ನಮ್ಗೆ ಏನ್ ಮಾಡು ಅಂತೀರಾ ಅದನ್ನ ಹೇಳಿ. ಹೌದು.
But I would like to place on the recent developments, namely the development that has taken place before the search committee and even the public.
ಅದನ್ನ ಅವ್ರ SLP ಹಾಕಿದ್ದಾರೆ.
ಮತ್ತೆ ಇನ್ನೊಂದ್ಸಲ ಏನ್ ಮಾಡಿದ್ರು ರಿಕ್ವೆಸ್ಟ್ ಏನ್ ಕೇಳಿದ್ರು ಇಲ್ಲ ಅದನ್ನು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ರು ಅದೆಲ್ಲ ಪೆಂಡಿಂಗ್ ಇರೋದ್ರಿಂದ ಡೆಮೋ ಮಾಡಿದ್ರು.
In the meantime, the Madras presiding officer is the Hyderabad presiding officer.
All right. See there. ನಾನ್ ಸಮೀರ್ ಒಂದ್ ನಿಮಿಷ ನಿಮ್ಗೆ ಸೊಲ್ಯೂಷನ್ ಬೇಕಾ ಬರೀ ಜಗಳ ಆಡ್ಬೇಕು ಮತ್ತೆ ಒಂದ್ ನಿಮಿಷ ನಾಯಕರೇ ಹೇಳಿ ನಾರಾಯಣ ಸ್ವಾಮಿ ಅವ್ರಿಗೆ 2 ನಿಮಿಷ ಕೂತ್ಕೊ ಅಂತ ಹೇಳಿದ್ರು. ಇವಾಗ ಇನ್ನೊಂದು 4 weeks ಮುಂದೆ ಹೋಗುತ್ತೆ ಅಷ್ಟೇ. ನೀವು ಹಿಂಗೆ ಮಾತಾಡ್ತಾ ಇದ್ದೆ ಇನ್ನೇನು ಆಗಲ್ಲ. ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದೀವಿ ಸ್ವಲ್ಪ ಮೌನವಾಗಿದ್ರೆ ಏನಾದ್ರು ಒಂದು ಸೊಲ್ಯೂಷನ್ ಹುಡುಕ್ಬೋದು. See now, solution is that defer all this proceeding, all that we are not agreeable. We don't agree with that. Now, in 4 weeks, if you can complete the entire proceeding and have an appointment. Yes, search committee has found out a person.
Search list has shortlisted.
Shortlisted.
Names are sent to the IB for.
IB. So once the IB comes, issue the notification.
No, IB, then they have to sit again and they have to recommend.
Whatever, do it as.
Recommendation then goes to the appointments committee.
So we can't stop all other, you will not stop the proceedings. What with Narayan Swami's grievance is that you have filed something. ಅಲ್ಲ ಇವಾಗ ಏನ್ ಹೇಳಿದಿರ ತಾವು ಇದರಲ್ಲಿ?
ಇಲ್ಲ ಅದೇ ಇವ್ರೇನೋ SLP ಹಾಕಿದೀವಿ ಅದು ಇದು ಅಂತ ಹೇಳ್ಕೊಂಡು.
Oh, defer the hearing till SLP ಅವೆಲ್ಲ ಆದ್ಮೇಲೆ ಅದ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. In the mean, we will do one thing.
Let them 8 weeks, my lord, by then I'll be able to reach.
We will call after 4 weeks. The meanwhile you try. Then 6 weeks al ಮಾಡಿ.
Lord, I will either report or I will give the status as of.
Under 4 weeks ಗೆ status ಕೊಡಿ. Status report in 4 weeks. Call on such and such date. Next matter. It appeal KIDB. So apparent wants time. Any urgency? All right. So even notice may not be issued by the court unless the notice has already been ordered.
ಪ್ರಕಾಶ್ ಎಮ್ಮೆ ಚಾಗ್ಲೆ ವಕಾಲತ್
ಹಾಕಿದ್ದೀರಾ?
R1
ನೋಟಿಸ್ ಆಗಿತ್ತಾ ಇದ್ರಲ್ಲಿ? ಆಗಿ So the bench has to hear whether it is a worthwhile case for receiving notice also. All right. Appellant seeks time, master on date. ಅದಕ್ಕೆ ಅದು ಬಂದಾಗ ನೋಡ್ಬೇಕು, ನೋಟಿಸ್ ಕೊಡ್ಬೇಕೋ ಇಲ್ಲ ಅಂತ ನೋಡ್ಬೇಕಲ್ವಾ ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕಾದ್ರೆ. ಏನಾಗಿದೆ?
ಡಿಸಿಗೆ ಹೋಗಿದ್ದಾರೆ, ಹಂಗಾಗಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೋಗಿ ತೀರ್ಮಾನ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ ಅಂತ ಹೇಳಿದ್ರು.
Parties have signed the memo, my lord.
So that instance, he refused the proof to file a and by mistake or otherwise.
Feel about.
Appeal is about to change the change of name in the father.
Correct them.
An application before the special.
Rahul Reddy.
Getting that.
45, correct?
45.
Yes.
1182.
So what do you want now in this appeal?
The change of meaning the father.
Who has changed the name?
The respondent number 4. On the basis of a failure.
It has been changed. No, now you have now withdrawn the suit. So whatever you want to do, you do it. Whatever now the change has taken place, it will remain as it is. Then you will have to see. Okay.
I mean, you are
That we don't know. No, we can't find solutions for it.
Civil suit.
This appeal will go. That's all. That's the only thing that we can do.
There are two.
There is nothing missed. Perfect. This appeal is directed against judgment and order date judgment.
Only for the reason that there was a mismatch in the boundaries.
Sir, please go there. Those are all vertical remedies. Why are we wasting time discussing that? This is not a legal advisory jurisdiction. They're all competent lawyers. Please take appropriate action in that. This appeal by the petitioner. Yes. This intra-court appeal by the petitioners, unsuccessful petitioners, is against order dated 11 8/20/22 in WP number such and such. Stop. ಇವಾಗ ನಾಗಮ್ಮ, ಮುನಿರಾಜು or how are they connected with others? They are not related.
They are purchased in.
Who came to this court earlier?
ಇವರೇ ಅವರೇ ಬಂದಿದ್ರು. ನಾಗಮ್ಮ ಮುನಿರಾಜನ ರಿಸಾಕ್.
So what is your case? You have purchased it.
But the original owners, they are not the owners.
So they sought for changing the khata in their name.
They are not, they saw the sale date of 1970.
They went, who went to the Tahsildar first? They approached the Tahsildar for entering their name in the revenue. Learned advocate for the appellant submits that petitioners approached the Tahsildar for entering their name in the revenue records based on sale deed date
9/6/1972.
9/6/1972. Your request was considered?
Yes.
Petitioner's request itlakade first ways was considered. ಆಮೇಲೆ ನೀವು 136 ಹಾಕಿದ್ರ?
Not aware of the fact that they had approached Tahsildar.
Tell us the facts, sir. Both parties simply saying something.
I can appeal to the Assistant Commissioner in Maharashtra. If I have to the 16/17.
Sir, original proceeding ಆದ್ಮೇಲೆ RA ಬರುತ್ತೆ. What is the original proceeding?
1986, they got their name entered in the Karnataka by.
That you challenged before RA.
But
What happened? Then?
Deputy Commissioner will direct the Assistant Commissioner into Tahsildar to remove my name and give a proof of action that they have to approach the Supreme Court and seek their remedy.
That has been dismissed by this. Perfect. Sri so-and-so advocate for the appellant dash it petitioners submitted that in the year 1996, private respondents got their name entered in respect of survey number 57/2,
1 acre 18 guntas.
measuring 1 acre 18 guntas and 43/1,
3 acre 6.
measuring 3 acre 6 guntas of petitioners challenge the entry, private respondents entry in the revenue records before the Assistant Commissioner in proceedings under section 136(2) of the 136(2) ತಾನೆ?
36(2).
AC ಮುಂದೆ 136(2) of the KLR Act, Karnataka Land Revenue Act 1964. Full stop. The appeal was allowed. Full stop. Private respondents challenged the said order before the Deputy Commissioner under section 136(3) of the KLR Act. Full stop. The Deputy Commissioner also allowed ತಾನೆ? Allowed the appeal and directed the Tahsildar to intimate the petitioners to approach the civil court. Correct? Feeling aggrieved, petitioners have filed the instant writ petition. By the impugned order, the Honorable Single Judge has directed as follows. Para 6. Stop. The advocate for the appellant submitted that they are the owners of the property. Petitioners are the owners of the property and their names have been deleted and the names of private respondents have been entered behind their back. Full stop. Learned advocate for private respondents submitted that private respondents have purchased the properties from the original owners and petitioners are in no way connected with the lands in question. Full stop. In any event, ತಾವೇನಾರು ಹೇಳೋದಿದೆಯಮ್ಮ? Right. Learned AG has submitted that since there is a dispute with regard to the title, parties may work out the remedy before the competent civil court. Full stop. The Honorable Single Judge has passed the say, has directed the parties to obtain a declaration from the civil court. Full stop. In view of the settled position of law, we are at one with the order passed by the Honorable Single Judge. As this appeal does not warrant any interference, fails, dismiss, no cause. All interlocutory applications disposed of. Having heard, this appeal has been filed belated.
Yes,
Having
pending
considered
IAS.
the appeal both on merits and delayed. Yes, next. What about others? Krishnamurti, Prashant? ಈಗ ಅವ್ರು ಯಾರೋ ಸತ್ತೋಗಿದಾರಂತೆ ಅವರೆಲ್ಲ ರೆಕಾರ್ಡ್ ಮಾಡಿ ತರ್ಬೇಕು. ಆಲ್ ಅದು ಹಾಕೋಣ ಆಯ್ತು. Mr. Chandrasekhar Reddy 322 submits that appellant has passed away, seeks time to take steps. 309 of 23 ಅಲ್ಲಿ ನೋಟಿಸ್ ಹಂಗಾಗಲ್ಲ, ಅದು ಕೇಳ್ಬೇಕಾಗತ್ತೆ ಇಂಟರ್ವ್ಯೂ ಇದ್ರೆ ಕರೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಇದ್ರೆ ಕೊಡ್ತೀವಿ. ಇದೆಯಾ? ಆಲ್ ರೈಟ್. ಏನಿಲ್ಲ, ನಮ್ಮ ಹತ್ರ ಆಟೋಮ್ಯಾಟಿಕ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಏನ್ ಏನ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ, ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮಗೆ?
Already we have spent about 46 crores, because it's about 140 crores.
ಇವಾಗ ಒಂದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಇದೆಯಾ ಹಂಗೆ? ಮಾಡಕ್ಕಾಗಲ್ಲ. Yes, objections, matters to be heard on the IAs. Please get the matter heard so far as IAs are concerned, then you press your respective claims. It's ಮಾಡಿರ್ತೀವಿ ನೋಟಿಸ್ 46.1 ನಲ್ಲಿ ನೋಟಿಸು, 46.2 ನಲ್ಲಿ PF etc. in 2 weeks. ಇದ್ರೆ ಅಷ್ಟೇ, ಸುಮ್ನೆ ಎಷ್ಟಿರುತ್ತೆ ಅಷ್ಟಿರುತ್ತೆ. ವಾಟ್ ಎವರ್ ಆರ್ ದೇರ್ ಐ ವಿಲ್ ಬಿ ಕಂಟಿನ್ಯೂಯಿಂಗ್. Sir, if it is there today, it will continue. Notice etc. ಇದರಲ್ಲಿ 46.2 ಅಲ್ಲಿ in 2 weeks. All right. Call on by consent, call on 31st January. Sorry, 29th January.
ಫೆಬ್ರವರಿ ಮಾರ್ಚ್ ಕೊಡು.
ಮಾರ್ಚ್ ಅಲ್ಲಿ ಕೊಡು. All right. 7th March. ಹಂಗೆ ನಾವು ಕೇಳದೆ ಕೊಡಕ್ಕಾಗಲ್ಲ. You already have suffered an order. So they kindly listen to us, sir. Right or wrong, if there is an interim order in this, if it has to be modified, ಬೇಕಾದ್ರೆ ನಿಮ್ಗೆ ಒಂದೇ ವಾರದಲ್ಲಿ ಕೊಡ್ತೀವಿ ಡೇಟ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತೂ ಆಗಲ್ಲ, 27th February ಕೊಡ್ತೀವಿ, ಅವತ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್. ಕರೆಕ್ಟ್, 27th February ಕೊಟ್ಟು 24th is a holiday. 27th, yes. ಅದೆಲ್ಲ ಮಾಡ್ಕೊಳ್ಳಿ ಅವರು. ಫೈಲ್ ಇನ್ ದಿ ಆಫೀಸ್. Wherever are there, ಎಷ್ಟು ಸತಿ ಹೇಳ್ಬೇಕ್ರಿ ಅವ್ರದ್ದು ಕೇಸ್ ನಂಬರ್ ಬರ್ಕೊಳ್ಳಿ, ವೆಕೇಟೆಡ್ ಇನ್ ಹಿಸ್ ಕೇಸ್. Next matter.
And give an arbitration, but only one small period of judgment aid.
Right.
Over.
Thank you.
And then there is delay of 105 days. These are the public. We've at our APS inquiry was ordered.
Sir, why are we discussing ಅದನ್ನ miscellaneous clerical office ನಲ್ಲಿ ಮಾಡಿ? Thank you. ಹಂಗ್ ಮಾಡಲ್ಲ, ಅದಕ್ಕೆಲ್ಲ ಎದುರುಗಡೆ ಅವ್ರು ಕೇಳ್ಬೇಕು, ಅಬ್ಜೆಕ್ಷನ್ ಇದೆಯೋ ಇಲ್ಲ ನೋಡ್ಬೇಕು. Thank you, sir.
Serial number 47, I appear for the appellant's counsel.
Yes, ಹೇಳಿ.
Serial number 47.
Yes, 47, ಹೇಳಿ.
Yeah, we are the
What is this rectification of office objection or IF4? What is IF4? Want to implead? Any objection for impleadment?
I will submit on that. It is unnecessary to implead now because we are in appeal against an order to which they are not parties. I may kindly be heard for.
No, 1 minute. 1 minute. IA4, you have objection. Fair enough.
Yes.
Any objections have been filed by the advocate on record?
No one.
We will file it today.
Please file it. They will file objection, then we'll hear.
But
Leonard
the
Senior
matter may
Advocate.
be heard for admission because I have been struggling so hard to get a date for admission in this case. Kindly look at the date when the matter was filed.
Fair enough.
And
Sir, now
whenever the matter reached, my learned friend on the other side sought for a short accommodation, and that short accommodation turned out to be a nightmare for us because only a very simple point that arises for consideration. If I am permitted. I request the court to kindly turn to page 71.
Please tell us the facts. In this code, we don't open the pages. We first hear and then open the pages.
I am obliged. Sir, applications were invited for appointment of assistant professors as guest faculty.
Very well.
On 22/7/2016, as per Annexure A, page 71. We were appointed.
Right.
Next day, we were terminated.
Right.
We preferred a writ petition. Again, there was an interim order, so that order was withdrawn. Thereafterwards, we filed representations for regularization. To consider our representations, we filed writ petitions, and those writ petitions were withdrawn because they promised to consider. Be that as it may, we continue to work. In the year 2021, we were unceremoniously terminated, against which we preferred writ petitions before this court. This court granted an interim order. Interim order was there. We were continuing in service, at which point of time a notification came to be issued as per Annexure. Yes. Page 193. These days, a notification was issued.
Yes, sir.
Inviting applications for appointment of guest faculty 2023.
Fair enough. Now, we read this order passed by the Honorable Single Judge, which is at paragraph number 5. So, how do you say that this is wrong?
I am obliged. Yes, this is wrong because, one, they had themselves invited applications for guest faculty. This information was suppressed.
All right. So now
we were not even allowed to place that on record.
Fair enough. Today, what is
look at the statement. There is no possibility. Sir, after this, the order, we have immediately preferred an appeal. But in the appeal, we have not been able to get the matter heard for preliminary hearing. For the first time, I am obliged
so now,
the court to.
Thank you.
All that we praise.
Yes.
Now, what they are doing, they are appointing from back door guest faculties or invited faculties or some other manner in which I am placing. My learned colleague is present before.
Right. So, who is appointing university?
Place those two statements were made.
Autonomous.
The principal. It is an autonomous college. The principal.
Euraja
he
College.
is doing it on
Who appears for Euraja College? You are appearing. Are you now appointing at this point of time any persons? You are not appointing. All right. Fair enough. We are not on.
Sir, kindly take the papers. My learned colleague is present.
Just, sir, learned senior advocate. Just 1 minute. Ms. Sungai is making some submission. We'll come back. See, Ms. Sungai, the point is this. Learned senior advocate's contention is that behind their back, now some appointments are being made. The submission was made before the Honorable Single Judge that there was no possibility to make any appointments, consequent upon which the para 5 is the order of which they are aggrieved. It says that in that event, respondents would like to make any appointment to post of assistant professors. Petitioners are permitted to participate in the selection process. Are you now doing anything?
It has not been done. It's discussed, you be paid on hourly basis, and under the acts, you can only appoint only for a period of 1 academic year, not more than that.
Fair enough. We are not. No. Please understand from our angle. The point is the matter requires hearing. What we are asking you is apprehension. Exact. So learned senior advocate is saying that you see behind their back, if the appointments take place, they will be put to difficulty. That's the whole point. So now we will record your statement that you are not making any appointments at this point of time. Correct? Yes. Heard Sri Ravivar Vakubar.
May make one submission.
Yes.
So, in fact, such statements are being repeatedly made, but it is false.
So what do you want us to do, sir? If Mr. Sungai is making
They
a
have
statement.
issued a notification inviting applications.
When?
Workload. We have demonstrated there is workload. We have placed before my learned colleague is present before the court.
So what is the date of that notification? Mr. Sungai today makes a statement before this court that no appointments shall be made pending this writ appeal without leave of the court.
Sir, on the other hand, the submission made to the learned single judge was a false statement in the light of the notification, page 190. Yes.
So we will do one thing.
Kindly see for a minute.
Fair enough. So what we'll
Sir,
do
they
is
had themselves invited applications.
perfectly all right. We appreciate your contention. So what order are you expecting today at this point of time?
Appointments are already. Sir, from 2016 we are working. Please put us back, subject to the outcome of the written.
So
there is workload. There are students.
We understand that requires a hearing. So hearing can be done after some time, not now. Now we'll protect your interest in the interregnum. We'll record a statement. They will not they will not precipitate the matter. They will not appoint anybody. You get the matter listed for hearing, whatever the
Sir,
we will
already
admit the
appointed.
matter.
Sir, they have already appointed. They have already appointed. Kindly take the papers, my lord.
Fair enough, but the point is it requires a final hearing, sir. Can we do it at this stage, the admission stage? You have an option. Either we'll admit the matter and record the undertaking of Mrs. Sungai, or we'll postpone the admission. You can take it. Take a chance.
Any date. No, any date.
All right.
Court.
All right. Admit.
Final hearing itself.
All right. Final hearing. Now you please give a date. Whichever is convenient.
Friday.
Which Friday?
Friday. This Friday. Yeah.
No. Not this part of before. Not in February, sir. Please. Final hearing andre March correct. We wish if it can be done. There are a lot of things.
The court, I will not take more than 50 minutes. I will not take more than 10 minutes.
ಸ್ವಲ್ಪ ಕಷ್ಟ ಆಗುತ್ತೆ. ಇಲ್ಲ ಅದಾಗಲ್ಲ. Sorry. Admit Shri. We understand that, but please excuse. Admit Shri Sungai, learned advocate for respondent number 2 submits that they call the 3 renew. Yuvaraja College, that is R3.
Sir, he made a similar statement. He was caught on wrong foot. Court said they will be sent to jail. Then he has reinstated other two professors.
Yes, sir. Submits that without pending disposal of this appeal, without no appointment shall be made.
R3 shall not.
No appointment shall be made by R3 without leave of this court. Submission placed on record. Sri Ravi Kumar and senior advocate seeks early disposal of the appeal instead of reserving such liberty for on 19th or 20th. ನಿಮ್ಮ ಮೈಗೆ ಅವ್ರ objection ಹಾಕ್ತಾರೆ ಆವಾಗ ನೋಡಿ ಅದು. Thank you. Next.
Yes.
Yes, please. Refund of? Yes, who has to pay that? That's right. BDA has not done. All right. Notice. Rajshekar. Yes, Mr. Rajshekar. So first you went to Tahsildar. Tahsildar did not give you. Then Assistant Commissioner. He granted. Then Deputy Commissioner. They went to the Deputy Commissioner. Then?
She said, go to civil.
Oh, whether your name was removed? Hmm? Hmm. All right. Sir, this is entering the name in the revenue record, correct? Who went to the Tahsildar for the first time for change? Whether you went or the private respondent went? Based on what? 2005. Your name was there. Your vendor's name was there. So now in 2005 they went to Tahsildar. Tahsildar granted them.
There was a state executed, notwithstanding pending this repeated cash. Yes, I think probably to migrate. Right?
Property on 28.
Not keeping good. That's exactly what I want to explain. 1972 is my failure. 1974 had tendency to be started. Once the tendency to start.
The civil court is the best place.
So now what can be done and in the appeal? The Honorable Single Judge has said, see, the order is paragraph number 8, correct?
None of my contents are
Order, sir. Nothing more can be done in this.
one aspect which requires my house.
Please tell us in writ petition what can we do?
I am not asking the regulator to decide it. My question is what to have considered the order of the
Ultimately, in this proceeding, what order are you expecting? Not you. All right. Notice. So you want him to go to court. Notice. Already ordered notice. Yes. GA except
private
notice for
respondents.
1 to 4 notice to private other respondents. Meaning? Yes. Status quo regarding revenue entries. So status quo regarding third parties entry ಮಾಡಬಹುದು ಅಷ್ಟೇ ಅದು ಬಿಟ್ಟರೆ ಇನ್ನೇನು ಮಾಡಕ್ಕಾಗುತ್ತೆ ಯಾರು ಮಾಡಬೇಕು ಅದು
ಕೋರ್ಟ್ಗೆ ಹೆಂಗೆ ಹೋಯ್ತಾರಲ್ಲ ಅಲ್ಲಿ ತಗೊಳ್ಳಿ.
ಅಲ್ಲಿ ನೋಡ್ಬೇಕು. ಇಲ್ಲಿ ನಾವು ನಿಮ್ಗೆ ಸರ್ಕಾರದಿಂದ ಮಾಡೋದು ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡ್ಬೋದು. ಅದು ಅವ್ರೇನ್ ಏನಾದ್ರು ಮಾಡಿದ್ರೆ ನಾವು ಅದು ಇಂಜೆಕ್ಷನ್ ಕೊಡಕ್ಕಾಗಲ್ಲ. Yes, please.
Chairman. Chairman of the people who are standing on the side of the they have come before, they are approaching. This is, either in this dialogue, now in the moment.
What is the prayer, sir?
Prayer is that the picture may be.
What is annexure F? What is that?
Guidelines for identifying the additional sample.
Hang. This is not a PA.
Oh, private litigation, is it? No, correct. But is it a PIL?
Yeah. Is it?
No, green bench is all right. But it is not a public interest litigation, right?
Actually, PAL.
In the river bed. They are the ones who are deprived of
No, they are not. See, it's a private list, meaning to say that if somebody's livelihood is affected, he must go to the court. Third party cannot go. It's fair enough, no problem. Sir, now kindly listen. Now the respondent has raised an objection. So it can be either sustained. No, we can't convert just like that. Now he has raised a preliminary objection. There must be a ruling on this. Either that the objection will have to be overruled or it must be sustained. Or after arguing the matter for some time, learned advocate for the petitioner seeks to withdraw. Has filed a liberty to do what?
PAL.
Adik, you don't need the liberty because you are not the affected party. Sir, you are an advocate. Please understand. The petitioner is an advocate. So what is sought is the livelihood of somebody else. It's a private list. Sorry. Please file a memo. Dismissed with liberty. Dismissed as withdrawn. Learned GA raises a preliminary objection with regard to maintainability on the ground that petitioner is a practicing advocate in Bengaluru and has no a private list is not maintainable. Full stop. So and so seeks leave to withdraw. Withdrawn, dismissed. GA permitted to file memo of appearance in 8 weeks. Next.
The last time apology killed. ಕಾಂಪನ್ಸೇಷನ್ ಲೈವ್ ವೈರ್ ತುಳಿದು ಸತ್ತವ್ರ ಕಾಂಪನ್ಸೇಷನ್ ಅಸೆಸ್ ಮಾಡಿ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಡಿಸ್ಕೌಂಟ್. ಸಿಂಗಲ್ ಜಡ್ಜ್
ಇಲ್ಲ ಇಲ್ಲಿ
ಇದು ಅಸೆಸಿಂಗ್ ದಿ ಕಾಂಪನ್ಸೇಷನ್.
ಅದೇ ಸರ್ ಇದು that we already
That's one point. The state point is.
no, we do not appreciate BESCOM taking this technical ground saying that writ is not maintainable, etc.
In this case, BBMP is also a party. Here the.
BBMP ಮೇಲೆ ಹೋಗ್ಲಿ ಬೇಕಾದ್ರೆ.
Both BBMP and the BBMP, that's why to get a components, the joint liability. And other, in your case, the BBMP contractor has been arranged as prosecutor. Because of the negligent act of BBMP contractor, this accident has been. So, the honorable judge.
So what do you want us to do?
And that point is not clear in the judgment, who has to pay what.
So from this pocket to that pocket, whoever pays, no problem. Dismissed.
The judgment, clearly, BBMP, which is the proper.
That is why we, now,
This is accident.
we told you in English. If you want, we'll tell you in Kannada. Both are same. BBMP under the Corporation Act, BWSSB under the BWSSB Act.
BBMP
ಎರಡಕ್ಕೂ ನಿಮ್ಗೆ ಸರ್ಕಾರದಿಂದಲೇ ದುಡ್ಡು ಬರೋದು.
BBMP is also party to the
BBMP had directed the concerned contractor to pay the money. According to the in another case, BBMP contract was not how to pay the arranged to the BBMP. And how pay the procedure.
Interdepartment under state article 12. State governments should not litigate at the litigation policy ಇದೆ. ECIL judgment ಇದೆ Supreme Court. ಅಲ್ವಾ?
Contract ಮಾಡಿಲ್ಲ.
ಅದಂತೂ ಆಗೋದೇ ಇಲ್ಲ. ನಿಮ್ ಕಾಂಟ್ರಾಕ್ಟರ್ ನಿಮ್ ಕಂಟ್ರೋಲ್ ಇರ್ತಾರೆ. You cannot make private parties to wait in queue. That is, we have taken that view, sir. We can't change that view. Sorry. Managing Director of BESCOM and one of the officers have challenged order dated 17/8/2023 in petition number such passed by the Honorable Single Judge directing payment of compensation of rupees 14,73,164 to the writ petitioners. Full stop. Heard she so and so. Next, continue. Heard she so and so. Full stop. Writ petitioners. Next paragraph. Brief facts of the case are legal heirs of one Krishnamurthy.
While walking near Kabrenalli circle, came in contact.
Legal heirs of one Krishnamurthy have brought the instant writ petition containing inter alia that Krishnamurthy died due to electrocution when he came in contact with a live electric wire. Full stop. Yes, on consideration of the material record. Pranay city there are ಬರ್ದಿದಾರ
ಬರಲಿಲ್ಲ ಇನ್ನೊಂದು ಬರಲಿಲ್ಲ.
Rajiv Singhal versus ಅದ್ಯಾವ್ದದು ಡೆಲ್ಲಿ ಹೈಕೋರ್ಟ್.
ಇದು ಇವ್ರು ಫಾಲೋ ಇದೇನು ಅಸೆಸ್ ಮಾಡಿದರೆ ಇಟ್ ಈಸ್ ಇನ್ ಲೈನ್ ವಿತ್ ದಿ ಪ್ರಣಯ್ ಸೇಠ್.
Honorable Singhal. It has followed, is it? What is said in MP electricity?
Page 7. Page 7 of the order.
No, in MP electricity, what is the statement of law? The positive and assuming that all measures liability cast on strict liability on the KV antana.
KV.
Are they on correct. So writ ಅಲ್ಲಿ maintainable ಇಲ್ಲ ಅಂತ ತಾವು ಹೇಳ. The honorable single judge has noticed MP electricity board versus so and so 2002 2 SCC 162 and taken a view that electricity supply corporation company is liable to pay the compensation and peruse the quantum of compensation
In para
assessed
13.
in para 13.
It is in compliance with Pranay Seth.
So the honorable single judge, we are of the view that the honorable single judge has followed
ಲೆಕ್ಕಾಚಾರ ಎಲ್ಲ ಮಾಡಿ.
has followed Pranay Seth. The compensation awarded is in consonance with the authority in consonance with Pranay Seth. Stop. Para. Venkatesh Ladder, advocate for the DESCOM, urge that bullet point 1. The honorable single judge has followed MP electricity board. He got that a writ petition is not maintainable in a case of this nature. And next bullet. The authority in MP electricity was in a case where the aggrieved party had initially approached the civil court. Semicolon. BBMP is also a party respondent before the trial court, in the writ petition. There is no ಅದು ಅವರು ಲೈಬಲ್ ಅಂತ ಹೇಳಿದಾರ ಪ್ಯಾರಾ 11
From the respondents ಅಂತ ಜಾಯಿಂಟ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ. From the respondents,
though it is ordered in the writ petition, though the liability is held as joint and several against both DESCOM and BBMP, the exact quantum, the ratio of liability is not forthcoming in the order. Equal stop. With regard to the first contention, that the writ petition is not maintainable, and the argument that the legal representative of the deceased ought to have approached the civil court. In similar circumstances, we have taken a view that
ಈಗ ಅವರು ಸುಜಾತ ಮೇಡಮ್ ಅವ್ರ ಜಜ್ಮೆಂಟ್ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಹೋಗ್ಬೇಕು ರಿಟ್ಮೆಂಟ್.
We have taken a similar view in such circumstances, in a similar matter. Full stop. RFL.
ಇವರು ಇಂಜಿನಿಯರ್ ಓದೋದು.
Krishnamurthy is not denied. His age and
Income,
the
notional
notional income is also not. Notional income is
ಇದ್ರಲ್ಲಿ ಬರುತ್ತೆ. Notional income ತಗೊಂಡೇ ಮಾಡಿದ್ದಾರೆ.
His age
Notional
also is not denied.
It is a notional income.
The honorable single judge has calculated the compensation based on the notional income. Stop. The date of death is 3/8/2014.
2014.
After, if the contention of the appellant is to be accepted, the party will have to be, the private parties will have to be relegated to the civil court after 1 decade. Full stop. Having noticed that the compensation has been computed based on Pranay Sethi, in our considered opinion, it would not be appropriate to relegate the parties, relegate the writ petitioner to the civil court after a lapse of nearly 1 decade. Stop. With regard to the second contention, that first and second contention are there because of that. With regard to the third contention, that the ratio of liability has not been fixed by in the writ petition, in the impugned order, we may record that both BESCOM and BBMPR are instrumentalities of the state.
Let them decide
Full stop.
themselves.
It is settled that there should not, the instrumentalities of the state or the state authorities shall not litigate interstate between themselves. We trust and hope that the departments, if aggrieved, can resolve the dispute inter se
Percentage of payment.
by approaching the administrative higher ups. That will be the matter. In view of the above discussion, we find no merit in this appeal. Appeal fails, dismiss, no cause. Delay idea?
Delay ಇದೆ 69 ದಿನ.
Yes, having considered the appeal both on merits and merit and delay. Full stop. I-82 for all interlocutory application disposed of. Next, Kavita Damodar.
If you are fighting, I am a business establishment having self-advertising. Self-advertising. My own holding with my own name in my own property. Under section 134B, there is no tax applicable on self-advertisement books. I have to be good, but all candidates are own name. The BBM bylaw also provides that in case I have not taken permission, I still have to take permission to say that I am at least putting up the board. Then I'll give 3,000 rupees. The demand rate.
So you have put a board in your premises and advertised your own product, correct?
Under 134, my own name, not my product, my own name. So,
You have put such a huge name. What do you do? You are a company.
No, I am not. Withdrawal.
Whatever. Target association.
So it's in my own name. Under section 134, there is no tax.
Yet you have to pay some 3,000. So now what has happened?
Demand 16 lakhs, saying that I'm carrying a covered advertisements.
Advertisement.
The bylaws, they say that no, bylaws provide. Section does not. Bylaws are clear.
But that also amounts to an advertisement, right? Please come to my hotel. I give following services. Here. All right. All right.
Notice,
Admit
as notice of.
interim order as great for with liberty. Yes, please.
Divorce daughter application for compassionate appointment.
Daughter.
One minor widow, daughter. ಇಂತಿ ಇಬ್ಬರು ಮಕ್ಕಳು, ಒಂದ್ ಗಂಡು ಒಂದ್ ಹೆಣ್ಣು. ವೈಫ್ ವಿಡೋ, ಮಗ ಮೈನರು, ಇವಳು ಹುಡುಗಿ. ಕೊಡ್ಬೇಕಲ್ಲ, ಡೈವರ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ.
So you are agreed by what? Now, what has happened by, what is the order by the Honorable Single Judge? Give the job. Consider, correct? Government has accepted, madam. No. In another case, the government has accepted the order passed by this court.
Married daughters.
Married daughters.
Married daughter.
Correct. Correct.
And she did five applications for marriage. But she says that she was unmarried. That is one. Secondly.
No, you may, if you have other technicalities, you may, you may consider that and then tell her that for following good reasons, I am not able to give you the job. That's a different matter. So what is the order now? Respondent college shall also take into consideration the respondent directed to consider the case on so and so on the premise that petitioner was unmarried daughter of. Was she unmarried?
Divorce.
That's not a problem.
So what? How does it make any difference?
Divorce ಆದ್ರಿಂದ unmarried.
That the rules applying on the date of the application will apply. Now, on that date, she was not entitled, one aspect. And
Who was not entitled?
The respondent did.
On what premise?
Because the rules.
Let us see, what is the date of application? 28/2020. So please, yes, tell us. What is the date of application? Correct, 28/2020. That's found in para 8.
Yes. The father is on 29/8/2019.
29/8/2019. 2019.
Yeah.
So this is in time? Within 1 year?
That is in time.
So application is in time. So what's your grievance?
Of filing of the application, clearly states that the candidate is 61. That the appointment under these rules. 2021 rules, thereby divorced daughter or unmarried daughter were included. Now.
Page 61, is it? Page 58. That's right. What does it say?
The case of the deceased female married government servant. In the case of the deceased female government servant, her son, daughter.
So what is the argument? We read that.
Now, I take your thoughts.
Please make out your point, then page number here. It is other way around.
That the application can be considered on the basis of the rules existing on the day of the application.
Correct.
This girl was not entitled to be considered because she was a divorcee. And divorcees were included pursuant to the judgment of the Honorable Court, which was upheld by the.
Oh, yes, I didn't, correct. As on 28/2020, she was, this rule was not applicable, isn't it? No, madam, we have taken a contrary view.
The ethics court has taken a contrary step.
Saying
That because of the various.
Please give him a copy. Please examine and then come back. If apex court has said something, then we have to see. Have you looked into this?
So I have taken this. The issue is with regard to
We have already taken a view earlier, maybe that's, but now that she is referring to a Supreme Court judgment.
In fact, notes what the honorable.
Mrs. Subramanian, please understand.
Yes.
Yes, identical question came.
Yes.
We have ruled holding that once the government has accepted, it must be given, whether notwithstanding that date, etc., no problem. Now that she is referring to a judgment of the Supreme Court. So, what is the rule, what is the law laid down in that? Please show that.
So that's it, can you keep page 19?
Please examine this and come back. That may be appropriate. We are post lunch. Doesn't matter. Does not matter, madam. We are not passing any order. So let Mr. Subramanian look into, examine this and then come back. That's all. Today may not be difficult today. Oh, please don't precipitate the content. That the matter must be, because if she says the Supreme Court judgment, please examine. Huh?
Also coming up before my lord. Then they could find out.
Post along with.
All right, post along with CCC number. All right. Post along. 20? 20.
It means, the fact it was blocked in to request for another date. If we had another date, it's not the next Monday.
Not possible. We have no time. We have already heard that matter. We are about to reserve. Please don't do this. Yes. Passer. Huh?
ಹೌದು 26 ಕ್ಲೋಸ್ ಮಾಡಿ
26 can be closed, no? Yes. Learned advocate for complainant submits that order has been complied. CCC closed. 20? 25 is a batch matter. What do you want? You want a change in date? 16th of March. All right, take it. What is the matter, sir? How can we?
Sir University Vice Chancellor case.
quarter. You can figure. Yes, Sajjan.
I'm sorry, my lords, I couldn't hear anything. I'm so
No
sorry.
problem. No
I
problem.
didn't notice that my lords convened my
Yes.
million.
Right.
My lords, may I make a couple of requests, my lords? May
Yes.
I request your lordships, my lords, at first instance, just 2 minutes, my lords. On the last occasion, your lordships were very kindly, lordships permitted me to take your lordships to the entire rules, the scheme of the rules, as to what should be done if there should be, my lords, order for taking down content on a platform. Incidentally, applies to me because I'm Twitter. There are a bunch of content which have been asked to be taken down. My lords, I'm only going to repeat one sentence out of it. The fact is, my lords, that I have complied with that order. In fact, even prior to I filing the writ petition, I complied with the order. I pulled down entirety of the content. Therefore, the order has worked itself out from the perspective of my lords, the union or anybody having any objections to it because I've complied. The second submission, my lords, the corollary to it is, although I have taken it down because an order has been passed, I challenged, my lords, that order on multiple counts. The third submission on that, my lords, I'm not going to the merits of it, is the Honorable Learned Single Judge, my lords, holds in my favor on locus, holds in my favor on the fact that I can mount a challenge, but holds against me, my lords, on one tangible point and many other incidentals. The tangible point being, and that's the most affected point for me, is that when an order is passed under section 69A and the consequential rules under 69A, that order need not within its body contain any reasons whatsoever for taking down the content. Not taken to its extreme position, it can be a one-line order saying, Sergeant Pavaya, you will take down the content which is in the schedule, and the schedule can have thousands of tweets and thousands of handles. I have to comply with it, otherwise I have a 7-year imprisonment under the rules. My lords, in that light, my lords, where it stopped was that I had, my lords, brought to your lordship's notice that under the very rules which we are talking of, which is the blocking rules of 2009, subsequent to an order of blocking being passed, which is, my lords, after traveling the entirety of it going before the designated officer, the committee looking at it, going to the secretary of the union, and the secretary sending it back, my lords, to the designated officer, and the designated officer passing an order. And that order, my lords, I'm so sorry.
Yes.
Yes, my lords. And that order, my lords, despite whether somebody challenges or does not challenge, by virtue of the rules itself, my lords, goes through a separate review process. This is not the checks and balances within the rules for the order to be made, my lords. This is a balance and check after the order is made, that it will go through a review process. In that review process, my lords, there will be an order passed by the review authority, who is the authority, my lords, under the telegraph rules. It is not an authority, my lords, under the 2009 blocking order rules, but it's an authority, my lords, under the telegraph rules, which is, my lords, imported into these rules for the purposes of review. That review order, my lords, will either do one of two things. Sustain the blocking order, which means the blocking continues, or, my lords, set aside the blocking order. And in the event of setting it aside, my lords, the content which has been blocked then revives, my lords, back on my platform.
Yes.
Permit me, my lords, to go forward from there today. My lords, for a minute, please see that rule, my lords. And therefore, an IA came up, I believe, my lords, I'm sorry, I was not present before your lordships. I believe my esteemed friend and the learned additional solicitor, my lords, indicated that they are willing to place the order before your lordships for my lord's eyes, but they are not willing to give us a copy. My lords, predicated on that, my lords, just one submission. Please see, my lords, the blocking, the 2009 rules. My lords will find the 2009 rules in the appeal itself at Annexure R2. That's where, my lords, it begins. Would your lordship straight away permit me, my lords, to come to Rule 14, my lords, pertaining to review, which your lordships will find, my lords, at page number 344.
Annexure R2 is at what page?
My lords, annexure R2, volume 2 of the writ petition. 341.
14. Rule.
My lords, may I make one request, my lords? I
Yes.
request the court officer, my lord, the camera moves back to the bar and I can't see your lordships because if there's any noise at the bar, the camera moves to the bar automatically.
Link with that. Automatically it goes.
ಅಲ್ಲಿ mic off ಮಾಡ್ಕೊಳ್ಳಿ.
Howdu, I'm grateful. That's it's voice activated, my lords, and therefore if there is voice
AORN, our voice.
344. 344 of statement of objections by the Union of India.
No, my lords. My lords, the writ appeal,
340.
writ appeal, my lord, 341 of the writ appeal, volume 2, my lords.
Correct. Regarding rule
yes.
14, meeting of the
Annexure
review
R2,
committee, then-
correct.
Yes, my lord. These were the rules which your lordships on the last occasion were very gracious to permit me to take your lordships through the rules. So I will not touch them. Please straight away come to my lords, rule 14, which my lords will find at 344.
Right. Yes.
My lords, please permit me to, with my lord's permission, read rule 14 and my lords read rule 16 because 16 talks of confidentiality and it will have some bearing, my lords, on the submission that I'm placing for my lords to consider.
Yes.
Please, my lords, permit me to come to 14. Meeting of the review committee. The review committee shall meet at least once in 2 months and record its findings. Well, let's kindly underline that. Record its findings. Whether the direction issued under these rules are in accordance with the provisions of subsection 1 of section 69A of the Act, and if it is of the opinion that the directions are not in accordance with the provisions referred to above, it may set aside the direction and issue an order for unblocking the said information which is generated, transmitted, received, or stored or hosted in a computer resource for public access.
Right.
My lords, 2 submissions, my lords, on this. The sequitur being, my lords, that a blocking order takes through a particular process in the rules, methodology of checks and balance before it is issued. Therefore, I comply, I pull down the content. Irrespective of anybody seeking a review or filing a review, whether, my lords, it is the originator of the content who is affected or whether it is a platform like me who is affected or anybody, the affected person not knocking on any doors. There is a statutory review automatically prescribed, my lords, that every 2 months there will be the review committee that will meet. My lords, kindly see which is this committee and I will, my lords, submit further on the rules. The definition, my lords, of this review committee is in rule 2I, which my lords will find at 341 of this very volume.
Yes.
My lords, kindly see in the definitions, the last definition, my lords. It's a small definition parenthesis, my lords. 2I. Review committee means a review committee constituted under section 419A of the Indian Telegraph Rules 1951.
Correct.
My lords, why I bring this to my lords' notice is this, that the committee, which is, my lords, a committee here under the Telegraph Act and the rules made thereunder, is a committee, my lords, which does not just look at aspects under the Telegraph Act. It also looks at, my lords, aspects under the Information Technology Act when 2 things happen, my lords. Like in my case, where when content is pulled down from a particular platform or, my lords, a particular handle or a tweet or a post, a Facebook page, or, my lords, a video is pulled down. It also, my lords, looks at, a committee, my lords, under the Telegraph rules also looks at aspects, my lords, when there are internet shutdowns. Farmers protest, for example, my lords, when internet is shut down. Or, my lords, any communal disturbance, my lords, people start spending whatever information, so internet is shut down. The language, therefore, now please, my lords, come back to, permit me to invite my lord back to rule 14. The language, my lords, in rule 14, page 344, is pari materia, my lords, to the language in, my lords, another set of rules, which is the temporary suspension of telecom services rules of 2017. Now, although this review committee rule was not a subject matter of any proceedings before the Honorable Supreme Court, the 2017 telecom suspension rules was the subject matter before the Honorable Supreme Court, my lords, when internet was shut down for an ostensibly long period in Jammu and Kashmir. And the Honorable Supreme Court, my lords, considering the rules as they stand here in Rule 14, and that is pari materia, I'll show it to my lord. For a minute, my lords, please permit me to walk my lords on the path that it is pari materia. But looking at a pari materia set of rules, which inherently do not have a language that the order must be published, etc., as in my lords, Rule 14 does not have a language. Nonetheless, my lords directed that it is inherent in a process of review, etc., where the order necessarily then must be published because a person affected by that order must have the opportunity to challenge it. Now, my lords, kindly see the predicated situation in which I am in. My lords, the learned ASG is my personal friend, my lords. I make no averment against his office or him or the position. But please permit me to be critical a little, my lords. And your lordships have seen me from the day I entered the bar. So let me, with my lord's permission, I'll be a little critical about it. Here is a union which says take down content. I comply, I take down content. I challenge it by virtue of a writ petition, which right I have to come before my lords. And I come before a learned single judge of this honorable court in a writ petition, saying that the procedure contemplated under the statute has not been followed by you when you asked me to take down. Therefore, please make sure that that order is predicated on the procedure that is followed. Not to say that please give me an order to revive the entire content. I do not seek such a prayer at all. It's not that I want to revive the content. But I say the order contemplates giving reasons. No reason is given. Therefore, that order is bad. The learned single judge says, no, the order and the rules do not contemplate that reasons must be given to you, which, my lords, I will come to that judgment. Now, be that as it may, my lords, I mount an appeal before your lordships. In the appeal, I'm sorry. My lords, in the appeal, the union for the first time places on record that there is a review committee that has met. The review committee has looked at these very orders which are in challenge, and the review committee agrees that these orders are correct, but says, I will not give a copy of the order of the review committee because it is quote unquote top secret. My lords, that flouts two things. If I am entitled to challenge an order, I have to be given that order. Now, in appeal, if the scenario is that there is a review order which also further supports the union, I have to have access to that order. Or the union says that the review order actually benefits the petitioner. Fair enough. I still have to have access. The union can't, my lords, say that they will place it before my lords for my lords' eyes. But I am the affected party. I will not give you a copy. Now, for that argument, my lords, please see Rule 16. Ostensibly, Rule 16 is against me, but I will make good as to why 16 does not, my lords, bite me. My lords, please see Rule 16. Requests and complaints to be confidential. Strict confidentiality shall be maintained regarding all the requests and complaints received and actions taken thereof. My lords, therefore, if a complaint is filed by somebody, my lords, I'll take a clearer example, a bottom of the quadrant example. A lady, my lords, complains that there is voyeurism and therefore some material about her, which actually, my lords, defames her or, my lords, puts her in bad light, is circulating on the internet. The, my lords, complaint, the lady's access, the lady's request, etc., my lords, should not be made public. For that matter, even in the present case, somebody would have asked, my lords, the designated officer to take down this content. The person who has asked the designated officer's identity or the request that is made by that person to the designated officer should not be made public. Now, action, my lords, which is being taken by the designated officer or for that matter, anybody else also need not be made public in terms of a publication of a gazette or publication in a newspaper or a journal or a report. My lords, because every ministry conducts its reports, my lords, on a periodic basis. It need not even find place in a report. But this Rule 16, my lords, does not indicate that a person who is affected by the order and has been asked to undertake certain overt acts by the order should not be given a copy of the order. Now, my lords, this issue came up, my lords, I'll, my lords, place that rules. The rules are, my lords, the telecommunication, I'll just read that. Temporary Suspension of Telecom Services Rules 2017. When this came up for consideration, my lords, in Anuradha Bhasin, my lords, before the Supreme Court, Anuradha Bhasin, my lords, took a particular view and permit me to, my lords, place that view before your lordships.
Temporary suspension of?
Temporary Suspension of Telecom Services Rules of 2017, my lords. My lords, before your lordships goes to that judgment, may I also, my lords, candidly say why I am requesting my lord to go into that judgment. It is my request, my lords, and if it meets my lord's approval, that if the union had not told us that there is no review order and there is nothing thereafter, I am challenging the main order. I am to mount my appeal also, my lords, on the main order. But now that the union says that there is a review order, and today if the union were to say we will not give a copy, then my lords, I would pray that there should be some order, my lords, based on my IA asking the union to give me a copy. Either it affects me, it does not affect me. It may support me, may not support me. But it can't be, my lords, I be kept in the dark and I am asked to fight my appeal, my lords, being kept in the dark. My lords, two things may happen. I either win or I lose. It can't happen that there is no third way here, my lords. Now, assuming I win, I go. And that order is, the review order is then used, my lords, by them in appeal saying, but see, the review order predicated it in stronger reasons. Or quite to the contrary, my lords, I lose. And my lords, what do I mount?
We got your point. Please come show us this basin.
My lords, yes, my lords. Now, please see, my lords, in Anuradha Basin. May I give me a minute, my lords? I'm just opening the judgment here with me. My lords, that is 2023 SEC 637. My lords, would your lordships permit me to straight away come to my lords? Paragraph 91. The judgment page, my lords, internally is 685. My lord, the position has changed. I'm sorry.
Yes.
The position has changed since 2017.
What is the statement? No, first thing is, what is the statement of law?
The statement of law, my lords, that in terms of the rule, my lords, or in terms of the proposition, my lords?
Where the rule,
yes,
if we understood you correctly,
yes, my
the pari materia rule came for consideration before the Supreme Court.
Yes, my lords.
Fair enough. So what is the statement of law made by the Supreme Court insofar as that pari materia rule?
My lord, the statement of law, my lords, is that all orders passed under the
paragraph.
rule.
Paragraph. Come to the show from the judgment.
Please permit me to show the rule, my lords, to show its pari materia, and I'll come to two paragraphs, para 96 and
Yes,
104. But please see, my lords, the rule itself in 92.
Correct.
Kindly see, my lord, in rule 2, sub rule 6, which my lords will find in page number 686, placitum F.
Placitum?
F, my lords. F of Foxtrot.
Yes. The review committee shall meet within 5 working days.
The review committee shall meet within 5 working days, in my case 2 months, of the issue of the direction of suspension due to public emergency or public safety. There, my lords, it is interim suspensions. And record its findings whether the direction issued under sub rule 1 are in accordance with the provision of subsection 2 of section 5. Identically for me, it shall meet once in 2 months and record its reasons, and that's the word, my lords, record its reasons to see whether the order is in, record its reasons, whether the direction are in accordance with the provisions referred to above, that is section 69, subsection A.
Right. So, based on this, what is the finding of what is the sequitur?
My lords, 2 sequiturs. Please straight away come to para 96, my lords.
Right.
5 lines in 96 and 3 lines in 104 and 160, my lords. I am reading 96. My lords, 96 is at internal page 687. The second requirement of rule 2.2 is the forwarding of a reasoned order of the competent authority to the review committee. My lord, that is for me, designated officer to review committee, which has been set up under the suspension rules within 1 working day. Composition of the review committee is provided under 2.5, etc. Please ignore that, my lords. Please come to my lords in placitum F. Rule 2.6 is the final internal check under the suspension rules with respect to the order issued thereunder. Rule 2.6 requires the review committee concerned to meet within 5 working days of issuance of the order suspending telecom services and record its findings about whether the order issued under the suspension rules is in accordance with the provision of the main statute, which is 5.1.5.2 of the Telegraph Act. My lords, my rules also records that it will meet and record.
That you have said, we have read, and that is exactly the fact is recorded here. Please show what this court says.
104, my lords, and 160, my lords. 104, please.
Yes, 104.
Yes, my lords. Now this 104, my lords, and I'll be quick, my lords. 104 is predicated on an argument that was raised even in the Supreme Court saying the rules do not require publication. Now kindly see 104, my lords, as a statement of law by the Supreme Court. It must be noted that although the suspension rules do not provide for publication or notification of the orders, a settled principle of law and natural justice is that an order, particularly one which affects the lives and liberty and property of people, must be made available. Any law which demands compliance of the people requires to be notified directly and reliably. This is a case regardless of whether the parent statute or the rule prescribes the same or not. We are therefore required to read in the requirement of ensuring that all orders passed under the suspension rules are made freely available, though through some suitable mechanism.
Yes.
Well, let's finally see 105. The above requirement would further the rights of an affected party. I'm sorry. The above requirement would further the rights of an affected party to challenge the orders if aggrieved. I stop there. I want to challenge that order is something I have indicated, my lords. And the union says they will not give it to me. And therefore an IA, my lords, saying that let them be asked to give it. And my lords, it's the same review committee in terms of the language. It is under the telegraph rules. One for internet shutdown, one for blocking of content, one before an intermediary, one before, my lords, a telecom
So
operator.
what do you want now?
All that I pray, my lords, is that therefore, my lords, I said it in the last occasion as well to the union. If the union says, I'm giving you a copy, whatever they pass it across the bar, I make no bones of it. I will take the copy. I will not further need time, maybe a day. Look at it. If there is anything I need to urge in it, urge and finish it here. It's not that I'll mount a separate challenge. But if the union says they will not give me a copy, I will pray at my lord's threshold that my lords may pass an order on my IA, my lord, directing them to give it to me.
Right.
Because in my writ petition, my lords, it's not that I'm raising it today. I raised a specific ground in my writ petition saying that there is a second safety mechanism of review. That review has not been complied with the union was a ground that I had raised in my writ petition itself.
We got it.
And therefore, my lords, I filed an IA, my lords. Of course, an order 11, rule 12 kind of a situation, my lords. It's IA 1 of 2024, my lords. Making a prayer before my lords that now they say that there is a review committee order. A direction be issued, my lords, to place the review committee order before my lords and then a copy to be given to me. My lords, please now permit me to, before I take your lords,
let us sort it out so that you can go further. Otherwise, it will stop at that point.
I know, my lords, and I don't mean to be, my lords, sticky about this, but please permit me to make this submission because
you raised a legal point, then you see we have to give a ruling on that. No problem.
Yes, Minister.
Perfectly all right. Yes,
but
government. Mr. Boya is pressing. Huh? No, not that. We are now. You have heard the argument. 2 points. According to Boya, this rule is in pari materia with 2017 rules. It reads following: cut, copy, paste. All right. If that be so, this Basin's case, para 104 and 106. What have I got to say? Where is the Solicitor General?
That if appellant answer this query of this problem after referring to section 2W of Information Technology Act, which says that the orders, starting orders are, I read section
2W of?
2W of Information Technology Act. In intermediary, appellant is an intermediary, there is no dispute with regard to that. With respect to any particular electronic records.
1 minute, appellant is an intermediary.
There is no dispute with regard to that.
All right.
With respect to any particular electronic records, mean any person who on behalf of another person receives, stores or transmits that record or provides any service with respect to that record and include those. Now, first and foremost, intermediary is not the originator of the message or the information. And drafting orders passed in relation to such messages or texts. And persons who are the originators, who are the account holders in the intermediary, I am not challenged. They are the one who say that my content, my message is not qualified to be blocked under rule section 69A of the IT Act. Here, the process of my learned friend's content is review order, whether the orders have been reasoned or reasons have been recorded, communicated, does not qualify to be stated by the appellant himself. Because intermediary's role is very limited. Suppose if he wants to get into the use, or if he wants to expose the causes of the account holders whose dues have been ordered to be blocked, then he is immediately under section 79, he has to go. Then my learned friend has to make a statement that whether he is exposed the causes of the account holder.
What does 79 say?
Exemption granted.
79 of the same act.
Same act. Exemption intermediaries not to be liable in certain cases. Because he complies with section 2W, he is exempted.
Exempted from what?
From other liabilities means.
Notwithstanding
Section 79.
time being enforced.
Exempt from liability of intermediary in certain cases. Notwithstanding anything contained in any law for the time being enforced, but subject to the provisions of subsection 2 and 3, an intermediary shall not.
All right, he shall not, for third party information.
Now, that information which we have passed the order to be blocked from access from public is third party information. And they are not before the court, they are not challenged. They are not coming forward. How my learned friend will be getting affected? And whether it is recorded or not, whether the review was held or not, review findings have been recorded or not, it is none of his content which can be raised at all, because fundamentally it goes to the root of the matter.
He is a third party.
That's third party information. The blocking orders are passed in respect of third party information, not in respect of the intermediary.
What was the case in, what was the, what were the facts in this Basen's case? If it's a pari materia, can we ask Mr. Sajan that you heard what the government is saying?
I have a straight answer to that, Millets.
Right.
Two submissions. One, the finding on this question is in my favor in the single judge's judgment. The union is not in appeal. The single judge holds that I have a right to challenge this because this intermediary, my lords, is actually, my lords, with great respect, a story that is being brought in unnecessary. The answer is this, my lords. I am an intermediary, yes. Is an intermediary liable under section 69A, not under 79? Answer is yes. Please read section 69A, my lords. The intermediary also, my lords, has penalty of 7 years. 79 is a safe harbor. In a minute, I'll explain 79. But please see 69A, my lords. And 69A is a standalone issue. It is not subject to section 79. Please see 69A subsection 3 straight away, my lords.
No, we'll come to that. But prima facie, what the government is saying, it occurs to us that what you are doing is you are facilitating third party to place their message, their content.
Correct.
So now the government is saying, please offload it, and you have offloaded.
Correct.
So who should be the person aggrieved?
Well, I have offloaded it at a threat of punishment. I am challenging it, saying if you want me to offload, you will tell me the reasons for offload. The challenge is not to.
No. Please, we are one step behind.
So I'm
always Sajan is very fast. Doesn't matter. No, it's all right. It's all right. No. What we are saying is, you are a platform. That's agreed. No question about it.
Yes.
Now that government asked you to offload, you offloaded. That's a different matter.
Yes.
But the question remains is, supposing if a content is uploaded onto your platform,
yes, ma'am.
And if it's offloaded,
yes, ma'am.
who should have the grievance?
Yes, my lords, this is the precise question. 2 submissions on that. Content is uploaded to my platform. There
Correct.
is an order to offload it. Now, please look at 2 circumstances. I offload it. I don't offload it. I
Correct.
offload it. Thereafter, my lords, I'll come to that phase. Now, assuming I don't offload it. I don't want to offload it.
That is not a scenario now. Now you have offloaded it.
My lords, it is a scenario, my lords, and I'll say why, my lords. When an order is passed to anybody, including an intermediary, to do certain things, the order must manifest why it is being asked. Otherwise, please see 69.3 for 1 minute, 69.A3. The 69.A3 is a direction to an intermediary, not to the originator to offload content. Please see 69.A3, an intermediary who fails. Now
Correct.
leave the originator outside, my lords. An intermediary who fails to comply with the direction.
From the court, we are asking a question.
Yes, my lords, sorry.
You are an intermediary, and the government asked, you offloaded it.
Yes,
So
my
who should have the grievance about?
My lords, 2 people can have the grievance about it. Now let us assume hypothetically that I have offloaded.
So straight away, we'll still cut short the time. Why you should have the grievance?
Yes, why I should have the grievance is because they recognize me as an intermediary under the statute. I am asked to do certain activity, failing which I have 7-year imprisonment. Then I have a right in the law to know the reason for which I am being asked to do certain things. Why? Because when I take down content belonging to a third party, my lords, my entire business is predicated on the fact that I am having a platform for somebody to say what he will say. If I have to take it off.
So if see, ultimately you may have a business on that. That's as far as the business model is concerned. Supposing if it's offloaded, the person can come back to you and ask, sir, why you have offloaded? I have a government order. So who should be the person who should have the grievance?
My lords,
we asked you this question 3 times. So anyway, we are only telling you. The person whose content you have offloaded.
Owner of the content.
No, my lords. 2 things. The owner of the content, no doubt, my lords, has a grievance. He may challenge, he may not challenge. He may challenge. I am not saying, my lords, I have a right and he does not. But I am, my lords, placing before your lordships that independent of the content originator raising or not raising, I have a right.
How is it hurting you?
Kindly, Shreya Singhal, my lords. Civil, please see 69.A3, my lords. Let me read 69.A3.
69.A3, we saw that. Sans that, as far as the content is concerned, you see, it is something like this. You are carrying the content in your platform, and the government thinks it inappropriate. Government tells, please remove it. Yeah, remove it. So far as the content and whether it is correct or whether it is not correct, whether it is affecting the government or any policy of the government or threat to nation. These are all matters. The person who writes that message, he must be worried.
Straight away, please come to my lord Shreya Singhal. I did not want to, my lords, run to that chase. I will show 114 of Shreya Singhal. And with great respect, the union's argument here, my lords, is superficial. This argument was raised by the very union before the Supreme Court in Shreya Singhal. And Shreya Singhal has held in my favor that an intermediary can challenge. My lords, please look at my lord Shreya Singhal, and my lords, please also come to my lords the single judge's order, which is in my favor, which is nobody's in a
that you show. First single judge's order, you show that.
Please come to my lord the learned single judge's order on locus. I would have wished for the union then to challenge it, my lords, then I could meet it. Please see, my lords, page number 115 of the paper book, volume number 1. So what?
One five of paper book. Please keep papers correctly. 200 and dot series 115.
And by the time the paper comes, my lords, on the question that fell from my lords, please also note, my lords, in the internet, the originator may be unidentified, and therefore the order is passed on an intermediary. Because half the time, my lords, some content which comes from a third party, my lords, they will put a spoof, they will put, my lords, a proxy server.
Yes, 115.
My lords, from 115, the locus argument starts. Please come to my lords 116. I will show 3 paragraphs, my lords, and stop. In 116, my lords, para B, please come to the middle quadrant of the page. My lords, I am reading, my lords, from the third line in B. Article 19 is contrasted to certain other articles with 16, etc., guarantees citizens, etc. My lords, I will not take hold to Newcastle. Please see, my lords, here. Guaranteed by the article solely on the basis of there being an aggregation of citizens, that is to say, the rights of the citizen composed in a body. It is true that in Puttaswamy versus Union, at so-and-so, Justice so-and-so, my lords, kindly see this quotation. As of now, as it is now clearly held, that the court that the rights guaranteed under 14 and 21 are not confined only to citizens, but available to non-citizens, aliens, or incorporated bodies, even if they are incorporated in India, even if they are, my lords, it should be not. There is a mistake here. I'll show the judgment. Even if they are not incorporated in India was the situation. Now, be that as it may, my lords, please come to the next line, my lords, on why very locus finding. Please come to, my lords, page number 125. I am not going through all the reasons. I'm coming to the finding, my lords. 125.
Yes.
My lords, in 125, after that English translation, etc., please permit me to read that line. The petitioner company is not only threatened. I'm sorry. Does my lord have, my lords?
Yes. Please go ahead.
The petitioner company is not only threatened of losing its protection under Section 79(1), but also penal action for violation of the mandatory provisions of the Act and the website blocking rules. In view of the above discussion, this court is of the considered view that the petitioner has locus standi to tap the writ jurisdiction of this court for redressal of its arguable grievance. What was my grievance in that writ petition? That they have asked me to block 1,100, illustratively in one order. There are many orders I have challenged. 1,117 tweets and Twitter handles were asked to be blocked by a one-line order. That was my grievance. I said, if I comply with this, I have a scenario where my business will go down the tube. If I don't comply with it, I have a 7-year imprisonment. And there is not even one word in terms of reason, let alone, my lords, one paragraph. My lords, please see the logic. I did not, my lords, trouble your lordships with the logic. Please go back to page 121. Please see
having said this, what precisely the Honorable Single Judge says to turn down your writ petition?
Yes, my lords. The learned single judge, and I'll take your lordships through that order fully separately, but in gist, my lords, the learned single judge says, Puvaya, do you have locus? Yes, you have locus, you can challenge. In your favor, I hold locus. However, you say that the order must contain reasons in itself. My lord, the learned single judge, my lords, brilliantly, my lords, legally puts it this way. The learned single judge says that order should contain reasons is your predication. But so long as I can find from the material available with the union that there are reasons in the union's mind and they are recorded elsewhere, therefore the order is not simply an order out of thin air. And if the court is satisfied that the action is correct, then simply because the reasons are not recorded in the order which is given to you, that is not bad. On that count, holds against me, says, your case is that the order given to you should have contained reasons. It need not contain reasons. My one word mounting the challenge before my lords is this. My lords, legally, there is a logic in what the learned single judge, my lord, says. But fortunately for me, my lords, that is in direct contradistinction to what the Honorable Supreme Court says in Shreya Singhal. By reading these very rules and the very section 69A, the Supreme Court says...
Let us see Shreya Singhal.
My lords, please. Would your lordships permit me, my lords, to read 4 paragraphs of Shreya Singhal? My lords will find that. Copy, my lords. The lordships, give me a minute, my lords.
Yes.
Permit me to come to... My lords, I have an SEC online version. I'm sure my lords have a true print, but the paragraphs are, my lords, similar. Please straight away, my lords, come to paragraph number 112. My lords, it is after the heading section 69A and the information technology procedure and safeguards for blocking of access of information by public rules of 2009. Copy. May I, my lords? I'm sorry, I didn't hear my lord.
Yes.
Lords, in fact, when my lords confer, the court master mutes it, my lords, and thereafter, my lords, your lords.
Rightly so.
My lords, what the court master does not know is we can read my lord's lips. We are lawyers, my lords.
Correct.
My lords, kindly see 112, please, my lord. My lord, section 69A of the Information Technology Act has already been set out in para 2 of the. I'm so sorry. I'm so sorry.
This way marked.
Yes, my lords, in that para 12, 112, please come to the last 5 lines. I'll straight away take your lordships only to relevant lines in those paras. Please come to the last line.
In addition to the above safeguard.
Yes, my lords, kindly see that one. And from there, my lords, permit me to read about 10-15 lines. In addition to the above safeguard, under Rule 14, a review committee shall meet at least once in 2 months and record its findings as to whether the directions issued are in accordance with section 69A(1), and if it is of the contrary opinion, the review committee may set aside such directions and issue orders to unblock the said information. Under Rule 16, strict confidentiality shall be maintained, etc., which I read. Now kindly see 113, 114, which talks of reasons. 113, Melons.
Yes.
The learned counsel for the petitioner assigns the constitutional validity of the 69A and assigns the validity of the 2009 rules. These very rules and the section. According to the learned counsel, there is a pre-decisional hearing. There is no pre-decisional hearing that is afforded by the rules, particularly to the originator. The union is now taking that argument. The originator of the information, which is defined under 2ZA of the Act to mean a person who sends, generates, stores, or transmits any electronic message, or causes any electronic message to be sent, generated, stored, or transmitted to any other person. Further, a procedural safeguard, such as which are provided under sections 95 and 96 of the Code of Criminal Procedure, are not available here. Also, confidentiality provision was assailed, stating that it affects the fundamental rights of the petitioners. Well, 114. It will be noticed. Well, this is the logic to uphold the rules. It will be noticed that section 69A, unlike section 66A, which was struck down, is a narrowly drawn provision with several safeguards. First and foremost, blocking can only be resorted to where the central government is satisfied that it is necessary so to do. Secondly, such necessity is relatable only to some of the subjects set out in Article 19(2). And thirdly, in my favor, my lord, this is, thirdly, reasons have to be recorded in writing in such blocking order. Kindly underline that, my lords. Reasons have to be recorded in writing in such blocking order so that they may be assailed in a writ petition under 226 of the Constitution. This is exactly my ground, my lords. I want to challenge it. I don't have an order which says why I should pull it down. My lords, I go forward. 115. The rules further provide that a hearing before the committee is set up, which committee looks into whether or not it is necessary to block such information. It is only when the committee finds that there is such a necessity that a blocking order is made. It is also clear that from an explanation of Rule 8, that it is not merely, my lords, kindly see, it is not merely the intermediary who may be heard. If a person, that is the originator, is identified, he is also to be heard before blocking order is passed. I stop here. Therefore, the first right to be heard is me, the intermediary. If they also can find who the originator is, let them hear the originator. And that is exactly why I have locus, my lords. Originators may not be identifiable all the time. Originators, my lords, for example, I have a website, I have a handle called, my lords, Goa Fish Fry. I, my lords, tweet spoofs on Goa Fish Fry. What is the handle? It is at Goa Fish Fry. Who is it owned by? It is owned by goafishfry@gmail.com. Now, who's the originator? Where is the union going to give a notice to the originator and ask him to hear? No. Therefore, the union says, no, I'm going to hear the intermediary because goafishfry@gmail.com put up some content on YouTube. So I will now call YouTube LLC the intermediary and tell them to block. And the counter argument here is, oh, these fellows are intermediaries. Why are they raising it? My lords, that was the question in Shreya Singhal. Shreya Singhal said, yes, put the reasoning in the order so that it can be challenged. Second, hear the intermediary. If you also find the originator, hear the originator. And my lords, And therefore, I predicate a simple writ, my lords. I only say, my lords, there is an order. I will comply with that order. But according to me, this order is bad. Why? Because there are no reasons. My lord, now let me show that order. For a minute, my lords, please permit me to jump the gun and show one order, my lords. Please look at, my lords, the order which is made. For that, my lords, 117 tweets. Please see how egregious that order is, my lords, in terms of one paragraph. It is a non-emergency order. My lords will find it, my lords, in Annexure B, my lords. This was, my lords, initially put by a sealed cover memo before my lords, which is, my lords, called sealed cover memo volume 1. The court master could pull that out, my lords. It was multiple volumes in one sealed cover. Annexure B, my lords, in the sealed cover memo volume 1. My lords, it looks as if it's a writ petition itself. On the top, it says volume 1.
Oh, that cover is in the safe custody with the registrar.
Oh.
And you have a copy.
My lords, we have a copy. We'll place that copy.
In seal cover.
I'm sorry. I'm sorry. That's why my lord mutes it. I'm sorry.
So now today,
sorry.
Right. Now today, what you are asking is, now I have filed an IA. What is the prayer in the IA?
My lords, the prayer in the IA, which I filed 1 of 2024, is that seeking at my lord's threshold a direction to the union, saying if there is a blocking order, please place the blocking order before court and afford us a copy of the blocking order.
And also the review. What about the review order?
I'm sorry. I'm so sorry. Not blocking order. If there is a review order, I'm so sorry. If there is a review order, please place the review order before the honorable court and give us a copy of the review order. I don't want the background deliberations, etc. I'm not entitled to claim that, my lords. I just am entitled to claim a copy of the review order. That's all.
Yeah.
My lords, I'll show this if my lord.
One minute before that, because now that it has come at highest. Have you filed your counter on this? Huh? See, Sajan is pressing for an order on Fair enough, but you must say something on the affidavit also.
My submission is, since he is not a original of the information itself, it's so intermediary.
For that, you see, you may be on a weak ground. Please, please note down his argument.
Punishment rather, not for the.
Please note down his argument. He's placing it. He's placing reliance on Shreya Singhal, and you can't just brush aside. There is a. Please read that order, para 114. All right, whatever that you see, we want you to put it on affidavit saying that now that IA is pressed, isn't it? Once the IA is pressed, if you don't want to file a counter and only argue, we'll record your statements. No problem about it. But if the choice is yours, if you want to say, oh yes, Mr. Kamath Larat, Solicitor General asked for respondent seeks time to file objections to IF 114.
Serving the copy on the applicant.
He undertakes to serve a copy of. Please give him.
My lord, they said that they did not file. I'm sorry.
You've seen the order. Then it's your choice. You want to put it, you can put it in writing. Otherwise, we will continue hearing. So we must give a ruling on that first.
Your objection will matte argument start.
All right. All right. So let them say whatever that they want to say on the affidavit. We'll take it further.
Please, my lord.
No, 104. Please come to 114.
What is the extent of his we are only talking about the contents of the.
No, it is not Sajan who is saying. It is the Supreme Court which is saying. For that, what is your answer?
Because we keeping section 2W and the Supreme Court order. Supreme Court order says first verify. If you identify a person as an intermediary, then we will issue a notice. What is the picture of the intermediary? Either he must give the details of the person where he maintains their details. All accounts are maintained in his property, not with the government.
Please come to 115. There are 14 and 15. We have share single with it. Right. No, no, no. Share single 114, 114.
Unlike section 68, it's a narrowly drawn provision with several safeguards. First and foremost, blocking can only be resorted to where the separate rule is expected that it is necessary. Secondly, such necessity is applicable only to some of the subjects set out in Article 18. Thirdly, reasons have to be recorded in writing in such blocking order so that they may be assigned in the disposition under Article 2.
Read 115. A combined reading you must say.
Yes, the person, the originally identified is also to be heard before a blocking order.
No. Rules further provide. Please read the complete sentence.
Yes. It's also clear from an examination of.
No, Mr. 115
115
starts with the rules further provide. Are you not?
Rules
Don't you
further
have a
provide.
copy of that? Then please read 115.
Rules further provide for a hearing before the committee set up, which committee then looks into whether or not it is necessary to block such information. It is only when the committee finds that there is such a necessity that a blocking order is made. It is also clear from an examination of Rule 8 that it is not merely the intermediary who may be heard. If the person, that is the originator, is identified, he is also to be heard before a blocking order is passed.
If he is there.
Now, the extent to which the intermediary can be heard means, perhaps you have to look at section 2W only. Because whatever the extent possible, you have to relate back to 2W only. Because all
That hair splitting argument, where the judgment, where the statute may be permissible, not where the judgment. Please put it on. See, this is no, we are upfront. We are telling you. Supposing if a statute is under challenge, virus of a statute is under challenge, it is wide open under 226. You can take any contention. That's a different matter. No problem. You can say that I will interpret it like this. I will interpret it like. For that, you can take the support of the authorities or something. Now he is placing reliance on 115 of the authority. In the authority, he is saying that the two words are important. One is the intermediate. Second is for a challenge under 226. So if we understood Sajan correctly, what he is hinting at is, look here, I have got the Supreme Court has said that I have got a right under 226 to challenge. And an intermediary also must be heard. And if available, that means the person who actually puts the content. If he is an anonymous or whatever, immediately he may not be available. It may be in some other country, something like that. Whatever, we don't know the contingency. In such a situation, if he is available, you can hear it. Otherwise, intermediary you must hear.
Yes.
If the intermediary is to be heard, read with that a contingency where he can challenge it under 226. So you will have to say something on that.
Same manner, sir. Immediately to respond to the last question, this order has been passed in the context in which how the intermediaries are functioning.
Correct.
Whatever the details it says, that are maintained by this detailed information only account order is not with me, not the any pictures account which are maintained by the intermediary. Intermediary has the repository of all the information of his account order, who is what.
Correct.
That's why in the situation, suppose nobody is there. Now intermediary cannot observe it that you are not identifying any person, please block it. There also it won't be a originator of any information. There again, we go back to section 2W.
So if you focus on the point, there are two supporting circumstances, two supporting paragraphs he is reading in his favor. according to him, number one. Number two, he has made an application saying that please ask them to produce this document and give a copy. Isn't it, Mr.?
Yes, yes, my lord.
Ask them to give me a copy. So you must say in writing that this is not applicable for this reason, whatever that you want to say. Please do that.
Full amend ಮಾಡ್ಕೊಳ್ಬೋದು. ಮಾಡೋದು. ಅವ್ರದ್ದೇ rule.
Yes.
Income tax ಅಲ್ಲಿ
ಬರ್ಕೊಳ್ಳಿ.
ಮಾಡ್ತಾರೆ.
Sri Sajan Poyal, senior advocate. It's a ruling on,
Order, interim order on a year.
seeks an order on IA number
1 of 24.
1 of 24. Full stop. After arguing the matter, so on 1 of 2024, Sri Kumar Leonard, the CGC, seeks a day's time to place statement of objections on behalf of Union of India for the said, on behalf of Union of India, full stop. When do you want? Sorry?
ನಂತರ memo ಹಾಕಿರ್ಬೇಕು.
Fair enough. Sir, we are not asking you to file an objection. No problem. Because, see, he wants us to give an order on IA. So we must say, Union of India has filed or not filed, no problem. We are not forcing you to file or. That's all. If it is there, we'll refer it. If it is not there, we'll read whatever, then what we'll write an order. Huh?
ASG objection ಹಾಕ್ತೀನಿ
Right.
ಅಂತಾನೆ time
Thank you.
ತಗೊಂಡಿದ್ದಾರೆ.
Thank you,
I'm
Sajan.
Grateful, my lord. My lord, this is my first appearance before my lord's bench as the Chief Justice. It's an
thank
honor. My lord. Personally, it's an honor. Grateful.
Right.
My lords, I'm so sorry, my lords. Before your lordship, let's go on
Yes.
the match. Would your lordships assign a date, my lords? Otherwise, it will just.
All right, all right. Which date is convenient to you, Mr. Sajan?
Day after tomorrow.
Government 14. Government bonds on 14 is all right with you?
My lords, if it's possible, would it be a little later, my lords? 14th is my lord, these are final hearing days, my lords. That's why.
Final hearing day. All right. You please tell us which is convenient for you.
My lords, may I pray for 16th, my lords, if that's all right?
16th, there will be no sitting here. 16th is in Kalaburgi sitting. 19 is Dharwad. Or it can be on 20th. 16 or
20th then, my lords.
16 or 20th. All right.
20 minutes. I'm so very grateful.
Yes. Thank you. Yes,
ಅದು
sir.
ಎಕ್ಸ್ಪರ್ಟ್ ರಿಮ್ಯಾಂಡ್ಗೆ ಅವರು ಇದನ್ನ ಏನ್ ವಾಟ್ಸ್ ಯುವರ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಕಾಸ್ಟ್
Huh? They are fine with for a remand order. How much time and how much cost? ತಮ್ಗೆ ಎಷ್ಟು ಬೇಕು ಹೇಳಿ ಅದ ನೋಡಿ ನಾವು ಇಲ್ಲಿ ಆರ್ಡರ್ ಬರೀ ನಿಮ್ಮನ್ನ ಕೇಳ್ತಾ ಇದೀವಿ ಅಷ್ಟೇ ಅದರಲ್ಲಿ ನೀವು ಹೇಳಲ್ಲ ಅಂದ್ರೆ ನಾವ್ ಎಷ್ಟು ಹೌ ಮಚ್ ಇದೆ ಅಮೌಂಟ್
11 ಲಕ್ಷ
Amount is 16,70,000.
what is the date on which you have given money?
No, my lord, it is like investment, my lord, so they are seeking refund.
Right, transaction is of which year?
22, my lords.
22, 16 lakhs. So now that, yes, Mr. Gogi, how much costs are you prepared to?
My lords, in 8 lakhs, my lords, under protest, we have paid them already.
No, that's a different matter. Now you see,
ಲಾಸ್ಟ್ ಹೇಳ್ರಿ
Mr. Gogi will not come. Gogi will not come free to the court. Simple. You calculate from your angle only how much fee you charge and tell him that is. He has to now do the
10,000,
entire.
my lords.
Sorry,
10,000, my lords, is my lords.
For what?
Suggest I leave it to my lord's consideration.
taking the certificate copy.
My lords, I'm sorry, my lords.
Then?
20,000, my lords.
He has run through the entire process of one.
I agree.
Decree.
My lords,
And
I
now
leave it to my lord's consideration.
has done.
ಬಂದ್ಬಿಟ್ಟು ಈಗ ಇವರು
I leave it to my lord's consideration.
No, please tell us. You see, let us be. That is why we make it here normally in our court by consensus, so that no lawyer, no party goes hurt.
20,000, my lords.
My lord,
Uh,
substantial amount itself is 18 lakhs, my lord.
Okay.
25,000 ಇಲ್ಲಾಂದ್ರೆ 15 ಲಕ್ಷ ಅಷ್ಟೇ 8 ಲಕ್ಷ ಆಗ್ಲೇ ಕಟ್ಟಿದ್ದಾನೆ.
The court fees 1 laksha katpittidevu.
All right. Allowed and remanded with cost of 30,000 rupees.
Parents,
It shall be completed, the proceeding shall be completed in an outer limit of 8 months.
6 months.
6 months, outer limit of 6 months.
My lords, my one submission, my lords. 8 lakhs.
All the case management, I think they will.
8 lakhs will go to commercial court.
My lord, it may be deposited in the court, my lords.
4 months.
In FD account, my lords, it may
All
be
right. The
deposited.
amount in deposit shall be placed in fixed deposit, and it shall be subject to outcome of the suit. It along with the interest, it shall inure to the benefit of the party succeeding.
Highly obliged. Highly obliged.
Date of appearance.
All interlocutory application disposed of, and without notice, party shall appear on. You are not filed Vakalatnama.
Today morning I got you.
All right.
Control act.
So and so undertakes to file Vakalatnama. The order sheet will be pulled. When will you appear parties without notice?
Any
Tell
day,
us.
my lords.
Next week? All right. That is on 26th March.
Highly obliged.
26th April. I'm sorry,
February.
26th of February.
Please, my lords.
All right.
Please, lords.
All right.
Please,
Parties
lords.
shall appear before commercial court on 26th of February.
Delay may not continue.
How much is the delay?
114 days, my lords.
Can condone? Yes, so and so has no objection. Respondent has no objection. I allow delay condone.
Highly
All
obliged.
interlocutory application disposed of. Yes, next. Next. 56.
Contempt.
No. What is the order? What is the order?
ಪೆನ್ಷನ್ ಕೊಡಬೇಕು ಅಂತ ಆರ್ಡರ್ ಆಗಿತ್ತು.
Pension.
ಕಾಂಪ್ಲೈ ಮಾಡಬೇಕು.
Yes.
Post along with writ appeal ಅಂತ ನಾವು.
All right. Learned Sudev Hegde's learned GA, no? Learned AGA submits that state have preferred writ appeal number such and such. Post along. All right. Post along. Commissioner. Do you under the?
2,94,00,000 BDA ಕೊಡಬೇಕು ಅಂತ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಆರ್ಡರ್ ಇದೆ. ನಾಟ್ ಕಾಂಪ್ಲಿಮೆಂಟ್.
Yes. Why it is not given?
BDA.
Your BDA.
ನೋಟಿಸ್.
Note.
2,94,00,000.
Learned AG accepts notice for 2, notice on 1. Let's say by person, because CCC is by person. ಅವ್ರು ತಗೊಳಂಗಿದ್ರೆ ಕೊಡಿ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ನಾವು ಆರ್ಡರ್ ಬರೆಯುತ್ತಪ್ಪ, ಅವರೇ ಬಂದ್ರೆ ಬೇಕಾದ್ರೆ ಹೇಳಿ, ಅವ್ರು ಬಂದ್ರೆ ನಾವು ಇಫ್ ಯು ಎಕ್ಸೆಪ್ಟ್ಸ್. ಎಸ್, ನೆಕ್ಸ್ಟ್.
Interim environmental compensation.
You have to produce some order from the NGT, is that right? Just hold on one minute. This is an interim thing, isn't it? Interim compensation.
Interim.
Industry. One is an interim compensation, which is categorized based on the size of the industry. 1 crore 50 lakh 25 lakh. That is one of the orders being challenged. Second is an order upon which we have calculated the environmental damage based on a common which is being given to
So
us.
that is also challenged.
That is also challenge.
It's a more ಇದೆ.
Combine
But challenge ಇದೆ.
as to be ready may not be correct, and because according to the player sheet.
Fair enough. What is the today's position? No, no. What are
Preliminary.
preliminary hearing? No?
ಇವಾಗ ಚಾಲೆಂಜ್ 3 ಪೆನಾಲ್ಟಿ ಒಂದು ಇಂಟೀರಿಯರ್ 54 370 ಇವೆರಡು ಫೈನಲ್.
It does not, it does not operate the whole concept of equal compensation. That was ready before.
All right, you say whatever you want to say in the counter. Fair enough, but the point is, let him say, no, this is preliminary hearing. It's petition.
They will not precipitate.
Oh,
Date of the order which is looked at.
There is a previous order of some court.
it is 2019. 5 years have elapsed.
ಈಗ ಬಂದ್ಬಿಟ್ಟು interim.
Without notice or the NGT order itself says.
We are not saying anything. We are accepting your statement. Yes, no, notice. Yes, yes. Notice, Mr. So-and-so accepts notice for, ಯಾರು state ಇದ್ದಾರಾ? You are appearing for all? For all persons, regional office, scientific office, for all. You are not given a copy? All right. Miss Andre, notice and so-and-so accepts notice for all respondents. Counted in 4 weeks. No. 2019 order. ಇಲ್ಲ 2019 order ಮಾಡಲ್ಲ. Please, sir, there must be a.
This is the order of the NGT.
Sir, you have come at your leisure after 5 years. So he needs to say, we need to hear him. Only when the matter comes on the board, the urgency will come. Please don't do that.
There is a previous order.
Could be, but what you have shown to us is 2019 order. Please have some patience. Take up.
24 ಇದೆ ಹೊಸದು ಇದೆ 3 ಆರ್ಟಿಕಲ್.
But whatever it,
You get page number 60.
let him come back. Thank you.
There is 2024 order. Well, I am not challenging interim compensation.
No.
We are not challenging interim compensation at all.
Are you taking any action now? You are not taking any. Till next date of hearing. All. Mr. Chaudhary submits that no precipitative action will be taken till next date of hearing. Which are placed on record. Next.
ಇದು GR ಮೆಡಿಕಲ್ ಕಾಲೇಜ್ ಶಿಫ್ಟಿಂಗ್ ಆಫ್ ದಿ ಸ್ಟೂಡೆಂಟ್.
Already taken a view.
ಇಲ್ಲ ನಾವು ಒಂದು ವ್ಯೂ W12 ಅಲ್ಲಿ ನಾವು ಕೊಟ್ಟಿದ್ದೀವಿ.
What do you want? Transfer? Same order.
ಉಳಿದವ್ರನ್ನೆಲ್ಲ ಶಿಫ್ಟ್ ಮಾಡಿ
Same order can be passed. You have already taken a view. You are appearing for whom? Union of India. ಯಾರವರು? College. You have any objection? ಇಲ್ವಲ್ಲ ಈ ವರ್ಷ ಅಂತೂ ನಿಮ್ ಕಾಲೇಜ್ ಅಂತೂ ಏನು ನಡೀತಾ ಇಲ್ವಲ್ಲ? 24-25. Then what?
ಮಜಾ ಮಾಡ್ತಿದ್ದೀನಿ.
All right. So learned advocates on both sides agree that this court in WP number 20206 of 2023 has video order dated 11/1/2024 has directed the state government to do what? Oh, Mr. Kheti is here. Yes, Kheti, what have we done? We will show your name, don't. Yes. No, what have we done so that we by in that order we have directed the union state government to transfer this person to some other college. Shall transfer all right. Andre Barkoli, on both sides agree that this issue is covered by the decision in 20206 of 2023 and the same order may be passed. Yes, same order, allowed and same. Petition dispose of all interlocutory applications disposed, if any. What do you want?
ಕೊಟ್ಬಿಡಿ ಯಾರ್ಯಾರಿಗೆ ಅಂತ
See, whoever is appearing, please give your appearance. You have the copy. You take it from them and give. It's all right. All learned advocates are here. Please give a slip that whoever so and so will undertake to appear. Permitted to file wakalat in 8 weeks. That's all. Yes, next. Deemed conversion. Why it's not done? Correct. We have held so. Justice Ramesh and isn't it the same order? H.G. Ramesh and that's under section 95 of KLR Act. Correct. ಕೊಡಿ ಅದೆಲ್ಲಿದೆ ಆರ್ಡರ್ ಇದೆಯಾ? So what should be the order? I have to consider the application date. Yeah, already filed the application. Annexure? Page 24.
Actually,
Learned advocate for the petitioner submits that the issue involved in this writ petition is similar to the one in WP 22990/2023. And full stop, petitioner would be satisfied if a similar order is passed. So Sudev Hegde, learned AGA in his usual fairness, does not refute this said statement. Hence the following order, page 31. Nimdo application date and ಹೇಳಿ
3/11/23.
3/11/2020. Noted. Annexure E na already passed in according to 107. So it's a deemed conversion. Period of 2 weeks. Correct. Same order. ಇಲ್ಲಿದೆ ನೋಡಿ ಪೇಜ್ 31 ಅಲ್ಲಿ ಮಾರ್ಕೆಟ್ ಪೋರ್ಷನ್ ಪೆನ್ಸಿಲ್ ಮಾರ್ಕ್ ಪೋರ್ಷನ್ ಸೇಮ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಇದು ಮಾತ್ರ ಚೇಂಜ್ ಆಗಿದೆ ಡೇಟ್. Yes, disposed of. You have filed your power? All right, 8 weeks. Sudev Hegde is 8 weeks to file power. Right.
Report.
ಏನ್ ಬೇಕು ನಿಮ್ಗೆ ಇದ್ರಲ್ಲಿ? ವಾಟ್ ಇಸ್ ದ ಪ್ರೇಯರ್?
This building has to be evicted. They have to demolish it and annexure E and E1 make kind of.
Annexure E.
How that planet?
No. Annexure E and E1. ಇವಾಗ ತಮ್ಗೆ ಏನಾಗ ಪ್ರೇಯರ್ ಏನಿದ್ರಲ್ಲಿ? Writ of mandamus so and so consider take necessary steps representation showing. ಏನಾದ್ರು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಏನಂತ ಮಾಡಿದ್ದೀರಾ? We did not understand. You must state the facts. There is some building, is it? Which one? Annexure E and E1 are the huge maps.
Annexure E is there is an existing office building is there.
Existing old building.
Office building.
Correct.
46.
Correct.
New taluk office. ಈ ಬಿಲ್ಡಿಂಗ್ ನ ರಿಪೇರಿ ಮಾಡಿ ಕೊಡ್ತಾರೆ, ಇದನ್ನ ಡೆಮಾಲಿಷ್ ಮಾಡಿ ಪಾರ್ಕಿಂಗ್ ಕೊಡಿ.
All right. Notice learned. Sudev, you'll take or you'll take, madam? Yes.
R1
Learned
to
GA
4,
accepts notice for 1 to
1 to
4,
4, housing board ಇದೆ.
housing board notice to 5. Yes.
In the meantime, they should not allow this board and elaborated within one of the department.
Who is allotting?
DC is now making the.
No, then why housing board is required?
Housing board is taken the construction work. This plan is approved.
ಬೇರೆ ಕೆಲಸ.
Please take in. So it can be a health hazard for others. So hold your hand for a while. Don't do anything. Complete your instruction. That's right. Complete your instructions with the deputy commissioner and also convey to him that in the meanwhile matter is pending. Don't precipitate the matter. That's 4 weeks to file counter. Learned AGA shall learned GA shall intimate the deputy commissioner Sri sentencing Sri Amritesh prays that an interim direction may be issued to restrain the deputy commissioner from making any allotment in the dilapidated building. Full stop. Learned GA seeks 4 weeks time to file counter. Full stop, granted. By interim direction, it is ordered that. Fair enough. We are saying that till next date, don't allot that. No allotment shall be made till next date of hearing. That's all.
Commercial appeal client reject ಆಗಿದೆ.
Client has been rejected. Why?
ಅಲ್ಲ 16 ಅಡಿಗೆಗಳು ನೋಟಿಸ್ ಹೋಗುತ್ತೆ.
Notice. R1. All right. Wakalatnama of Caveator R2 and R3 accept. Notice next line. Wakalatnama of Caveator R2 and R3 accepted. Notice to R1 and 4 is it?
R1, R4 to R7.
R1, R4 to 7. All right. AOR is also permitted to serve the learned advocate who appeared in the
Commercial court. And commercial court.
Commercial court. They may not come here. May not accept. That's it. Counsel, if he accepts because that stood terminated. No, if it's a writ petition, that's all right. It's a continuation process. There, the proceedings stood terminated before the commercial court. Even if he receives, it will not become service to the party.
ಅವರು ಇಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸಿಗೆ ಬಂದ್ರೆ they will come.
No,
If
fair
they
enough.
don't come here.
No, please see a scenario. Supposing we have no problem. You serve to the advocate. We can't treat it as service held sufficient. That's the point. If they come and appear, no problem.
I'm seeing it. In addition to it, what I'm doing.
Then a memo will come. Please hold the service as sufficient. So it's not a service to the party. That's the whole difficulty.
I will not file that memo saying hold the sufficient.
As a in addition, learned senior advocate prays that the AOR may also be permitted to serve a copy of copy of this COMAP to the learned advocates who appeared before the commercial court for forwarding the same to their respective clients. Full stop.
Also, that the parties will also send the email.
Email you can serve even now also. Email, WhatsApp, and also via email and WhatsApp. No problem. 8 weeks. All right.
Sometime in March.
No problem. Return notice returnable on 26th March. Yes, Josh.
Respect of award of the state must after 10 years by the arbitrator. I directed to the people.
34 dismissed.
It's not a contract at all this. Look at subsequently 14 police.
So what has happened now?
They have dismissed my 30 problems. And I haven't.
Correct.
They put me in possession for the court.
What is the resultant position? What is the resultant position? Resultant position. Award has been. That's okay. What is the, at the end of the day, you know, this, what is the arbitral award?
The award says first my treasure.
9.4 lakhs with 9% plus.
Right, notice. You are in possession of?
Of the property loss. Because I was put in possession with respect to the MOU.
So what is the list about?
The list is with the specific performance.
You are a purchaser.
I'm a builder.
You are a purchaser,
I'm a
builder. So wanted to purchase that property or build.
I am entitled to 60% there and I.
So what is that you are asking now?
Plus, I'm saying that status code, they cannot create third party rights.
Did you have this order before?
Yes, sir. From 1999 till the section 34 was.
I didn't know. That appellant had the benefit of interim order of status quo.
Injunction was granted, which continued in one matter.
Now A1 ಹಾಕಿದ್ದಾರೆ ಅದಕ್ಕೆ A1
Submits that other opening sentencing. Joshua submits that appellant is in possession of the sued property. Appellant had the benefit of an order of temporary injunction before the arbitrator. Arbitral tribunal as also before the commercial court. Full stop. Submission placed on record. Status quo regarding possession.
Create third party rights.
Notice agi barli. Let the notice go in.
ಅದ 5 ಲಕ್ಷ ಇದು
Not a case to review. No. It's all right. You may have a case, meaning to say not a case for review because we have ruled something. Maybe in your perception, that's a wrong order. No problem. We completely agree with you with your submission as a professional. We have not taken it amiss. But the point is, the order cannot be reviewed. Order can be set aside if the superior court finds it a problem. No. No, it's not that. Sir, please understand. Every lists will have an order on merits, order on costs. So by considered order, we have passed an. That's all.
Because what I wanted to commit to, but between those 2 days.
Adantu now the touch model. I had no merits dismissed. Next. Want to file objection to
ಇದು
for
3
IA.
ಕೋಟಿ 19 ಲಕ್ಷ ಅವಾರ್ಡ್ ಆಗಿದೆ 3 ಕೋಟಿ 19
The caveat respondent has entered caveat. Is Vakalatnama accepted? Melgade notice notice. Respondent has entered caveat. His Vakalatnama is accepted. Sri Rashikar seeks. Yeah, it's his 10 days to file objections to IA1 of 20.
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದಾರಂತೆ
You will not precipitate for 10 days till next date. We'll admit this.
ಸ್ಟೇ ಬಗ್ಗೆ ಇಲ್ಲ ಅವ್ರು ಬರೀ ಅಡ್ಮಿಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ ಅಷ್ಟೇ ನಾವು
ಅಲ್ಲ ಇಲ್ಲ ನೀವು ಹೇಳೋಂಗಿದ್ರೆ ಹೇಳಿ. How much is due?
The matter is prior to the plaintiff becoming the owner, I was a lessee or licensee, whatever name they want to call. And I was admittedly paying 18,75,000 as rental. The deed of the previous owner is produced. It says 18,75,000 includes the tax. Page 320.
So now it is only about the tax, is it?
Now what has happened is, they go on adjusting the amount paid by me towards tax and hold that rent is in arrears.
All right, then nothing, not even addition, just counter for I1 up for 24 in 10 days. Shri Rashekar submits that respondent shall not precipitate the matter till next date of the date action. Huh?
I appear not in the next matter.
This is the matter.
Online.
B group.
If
Your lordship said not directed.
So where is Mr. Haladi?
The lordships had posed a question to them. What is it that I was expected to, which I did not do?
Correct.
Because your lordship saw, my lord, in this case, the high power committee accepts it.
Right.
And the only reason they give is that we did not take NOC from KDB. When KDB writes to say that we don't give NIC when property is sold.
Mr. Haladi is not here.
well, the last time you
Will it be tomorrow then, my lord?
contemplated.
Mr. Naganand, the senior advocate for the appellant, none appears for for R2 and 3 for BDA and for BDA.
Could it
when
be
do you-
tomorrow, my lord? Tomorrow, my lord, because your lordships have already heard the matter, my lord. I won't have any more submissions to make. All the documents, only question which your
All-
lordships were pleased to pose.
All right,
was-
tomorrow, please ask your AOR to inform Mr. Haladi.
Yes, ma'am,
Again.
we'll do that. We will inform him.
Right.
Great.
Finally, hearing Gagalam. We are raising, we have to go.